Good morning, everyone. That was pretty good. You guys are better than yesterday. Give us a moment while we get all our technology set up. If you see me, I have my phone up here, but it's to keep time on things, so I'm not up here checking things, just so you're aware. As Kevin said, my name is Christopher Trebilcock, and I am serving as the presiding judge for today's panel. I'm joined by my colleagues, Judges Seema Patel and Randy Wallace, both like me from the 2nd District of the Court of Appeals, which encompasses Oakland, Genesee, and Macomb counties. We welcome you to the second day of our Detroit case call for December, and we are panel 1. We recognize that these cases are important, both to litigants and counsel. And often our decisions are the final word on the dispute or problem that gives rise to the case coming before us. I can assure you that we have been diligent preparing for today. We've read all your briefs, had the benefit of the briefing, the record that's been provided from the case below, and we have reviewed it coming in to today. And we have a full schedule today, and I want to cover some basic ground rules for everyone. And for some of you who maybe this is the first time in the Court of Appeals. First is each party is allotted time to provide oral argument as provided in the court rules and procedures. If there is, second rule is that if there is more than one attorney appearing on a side, we ask that you let us know at the outset how you may be dividing your time. Third, and this is for the appellant, please let me know at the beginning of your argument how much time you would like to preserve for rebuttal. That way I can help keep you on track and advise you if you're up against the time. Fourth and final rule is that if your case involves children, sexual assault, or other sensitive topics, please do not mention the parties or the children's names. Instead, please refer to them by their initials or other private identifiers. This is a recorded public hearing, and it appears on the Court of Appeals YouTube channel. So everything we say and do in here is for the public viewing. So please be mindful of that. My last comment before we call the first case this morning is advice based on my own 20 years appearing before the Court of Appeals and my brief time here on the bench. And my advice is this: we are very familiar with the relevant facts and the pertinent case law. I strongly urge you to focus your limited time on any of the key pertinent facts only, and really hone in on the specific issues that are dispositive to your case, and answer any questions that we have as directly as possible, because if we're asking questions, it generally means it's something that we have a concern with or feel is key in your case. With that, let's call our first case, item number 1, docket number 16, case number 369967, People of Michigan versus Eric Jermaine Compton. Counsel, please approach.
Good morning, Your Honors. May it please the court, Melissa Krauskopf on behalf of the appellant in this matter, Mr. Compton. I don't have anything to add to the briefing that I've submitted to the court. I think everything is pretty laid out from both sides, but I am happy to take any questions if the court has any for me.
No questions. Thank you, counsel. Well briefed.
Thank you.
Your job's easy now, right?
Good morning, Your Honor. Emil Sama on behalf of the people, standing in for Jonathan Misek. I will rely on my brief, well, his brief as well, and I'll answer any questions the court may have.
Any questions for counsel?
Okay.
Now, if they all could just go that smoothly today, right? Thank you, counsel. Don't get any ideas in the between, in the interim. Yeah, there you go. That case is submitted. Moving on to item number 17, case number 372-059, People of Michigan v. Terrence Bernard King. Counsel, please approach and provide your appearances for the record. One remote. Ms. Young is remote. Ms. Young, can you hear us?
Yes, I can.
Okay. Please state your appearance for the record.
Laurel Kelly Young on behalf of Terrence King. And the issues in the brief, I also don't have a lot to add other than I think that they knew very well where he was. His co-defendant had been brought up to Michigan, and that just that they knew where he was, and they just, for whatever reason, let him languish. And he lost the time of the concurrent sentencing.
Okay. So just to clarify, the main witness, Mr. Gage, he was still called and appeared and gave testimony at trial. Is that correct?
Yes.
And
Yeah.
our understanding, or my understanding of the record is that there's no allegations, or at least in the briefing, I didn't see anything that suggested his testimony was affected or impacted or changed at all by the delay. Is that correct?
I would agree with that.
Okay. Anything else? Clarification or questions? Thank you, counsel.
Thank you.
And good morning, Your Honor. Emil Simon on behalf of the people. My brief, I think, lays everything out. Unless there's any questions for the court, I'll rely on that.
No questions. Thank you,
Thank
counsel.
you, Your Honor.
Thank you, counsel. That item is submitted. Calling item number 18, case number 372-377, People v. Everett Ramon George. Counsel, please approach and state your appearances for the record.
Good morning, Your Honors. May it please this honorable court, Ashley Aplustis on behalf of Mr. Everett George.
Morning.
If I could just have 2 minutes for rebuttal if necessary.
You got it.
I know that this court has read my brief. The one thing that I wanted to emphasize that I don't know I emphasized as clearly as I would have liked to in my brief is the reason why that this plea was not knowing and voluntary is because of the fact that both the prosecutor and the defense attorney put an estimate on the record at the plea hearing. Had this been simply the judge agreed to bottom third of guidelines, we will calculate that at sentencing, and that was the agreement, that would have been one thing. At that point, I would agree my client would not have had the right to say, I didn't know. But the fact that 2 of the smartest people in the room, insert lawyer joke here, the fact that they both agreed it's either 30 or it's 45 months, but they both put it on the record. They're both within a reasonable ballpark, and then we get to sentencing and it doubles. The same as when you go take your car in, you get an estimate, you agree to it, and then when you pick it up, it's twice the price of what they told you. You relied on that mechanic to give you a reasonable estimate, and you relied on their expertise. And when you get to checkout, it's double that. You can't say it was knowing at that point. So that is the only thing I want to emphasize is had they not put any estimates at all on the record, we would be looking at a completely different story here, but they did.
Also, was some of that information available to calculate the guidelines accurately?
I believe it was, because the 4 points that defense counsel claimed was the reason that the guidelines changed, that doesn't make sense because the 4 points didn't change that guideline range. The PV1 was scored at 25 points, and that was a prior conviction that they used to establish the habitual offender. They knew about that. The same thing with PRV7. It's 2 offenses that were being pled to and charged to. They knew about that. The 4 points didn't matter. So it should have been calculated at 75 from the get-go. That's the numbers that I got from the beginning.
Any other questions?
No, are you 100% sure that you want this is I guess my question. I mean, because if he gets convicted again, there's not going to be any kind of an agreement, I would assume, and then he could be sentenced at the top of the guidelines and he could be even more time.
That's correct. And that is absolutely something that he has had to consider, and I'm here. So,
Understood.
but that is a point that was brought up and was considered.
Thank you, counsel. Well briefed.
Thank you.
Morning, Your Honors. May it please the court, Joshua Miller from the Oakland County Prosecutor's Office Appellate Division on behalf of the people. We're asking the court to affirm the convictions and sentences in this case. To briefly begin by addressing the point counsel raised, the problem with that argument is that it was also made clear that those were just preliminary estimates. And it was said on the record that they were preliminary estimates. Both the prosecutor and the defense attorney said this is going to be bottom of the guidelines as calculated at sentencing. And as the
Was defense counsel's conduct below the standard of a reasonable attorney at that point in
well,
terms of the calculation that he made and the advice that he gave his client? based on it?
No, Your Honor, because there is binding case law, Fonville and In re Oakland County Prosecutor, that says a defense attorney's misestimate, that's not a word, but incorrect estimate of a sentence is not a basis for an ineffective assistance of counsel claim. I would also point out,
But didn't we have more than, sorry to interrupt you, but didn't we have more than just defense counsel? I mean, the prosecutor gave the same statement on the record.
that's correct, Your Honor. But again, they made it clear, these are just our preliminary estimates. Everybody was aware that it's guidelines as calculated at the time of sentencing. Defendant himself said that he agreed that when he was doing the plea colloquy under oath, that he understood
So
what had been placed on the
doesn't
record.
that just set up a system though, counsel, where, you know, that any estimate why would a defendant then ever start trusting what is stated when they're taking a plea if the rug can just be pulled out from underneath them? You could get all these assurance, say, yeah, but it's preliminary. And then they show up. Doesn't that just, then the whole system falls apart?
I think so, Your Honor. You will have cases where there are changes, but the problem is that the defendant is also aware of his own criminal history. And if there's something that the attorneys and the prosecutor miss, which it appears that's what happened in this case, they probably forgot to factor something in when they were doing their preliminary calculations.
But isn't that the whole right of a right to counsel, is you need someone who's skilled and trained in the law to give you the advice that you then can rely on?
It is, Your Honor.
So isn't then if you get it wrong and they mislead you, isn't there a remedy then that person's entitled to?
Well, Your Honor, the question that is it, number one, is it deficient performance? If they make an incorrect estimate, and this, as I pointed out, this court has held that it's not. But to that point, oh, excuse me.
You need some water?
Please, yeah, please go ahead and get some water.
Pardon me.
No
I
problem.
don't know where that came from. I'm sorry, I lost my train of thought.
The question I was asking was about the whole purpose of having a right to counsel and being able to trust that counsel and them being there for the advice.
Yes. And I think that the crux of the question is, was there an intentional misleading? Because counsel was doing his best to make those estimates, but if information isn't available to him or he's questioning something.
What about counsel's point that, the information was available because it was a predicate for two of the other charges?
I'd have to look at
Or the other scoring, I believe she
I'd have
said.
to look at the exact scoring to see what it was they actually missed. Because if it was something that they only became aware of after the plea was entered, then absolutely counsel is not, neither counsel nor the prosecutor acted ineffectively or misled the defendant at that point.
So to sort of summarize your position is no harm, no foul.
Essentially, yes.
Okay.
But the other point I was going to make in addressing Judge Patel's question is to the extent that this is a claim of ineffective assistance of counsel, it's not even properly before this court because it wasn't raised below. And the court rule is very clear that if you're going to raise a claim on appeal as a basis for plea withdrawal, you have to raise it in the motion to withdraw your plea. And that's 6.310D. Ineffective assistance of counsel wasn't raised as a basis below. So to the extent that this is a claim of ineffective assistance of counsel, it's not properly before the court, and the court does not need to consider it. And there's, again, case law on that point. I believe it's the Cordaway case, which I cite in my brief. Let's see. The last point I wanted to make is, aside from the fact that the defendant in this case affirmed under oath that he understood that this was sentencing at the bottom of the guidelines as calculated at the time of sentencing, which again, the parties had both placed on the record. All of the statements that are now to the contrary are unsworn statements. It's just the defendant apparently being dissatisfied with his sentence, which case law again tells us is not a basis for plea withdrawal. So at the very least, if this court is going to go down the road of saying this could be ineffective assistance, I think that prior to this court reaching that conclusion, there should be at least a Ginther hearing to determine what exactly everybody knew, because we don't have, to the extent it is an ineffective assistance claim, we don't have a complete record as to what the attorney knew, when he knew it, et cetera, et cetera.
Is it as important what he knew as it is? How important is it that we know what he knew versus what he could have known
I think
with reasonable diligence?
I think if we're going down the ineffective assistance road, I think it is important what he knew, but also where he got that information, because if then it becomes revealed that yes, he could have gotten this information sooner from this source, and then I would agree that you could be moving into the realm of deficient performance. But if it was something that came completely out of the blue to him, then it's a very different kettle of fish.
Any further questions?
I think the biggest problem here, I think, is that it would be one thing if what was said at this hearing was, we think it's going to be 30 months, but we need to look at all the final data in order to determine that. What was really communicated to this defendant was, okay, we're not sure what the actual numbers are, but they're either 30 or 45. In other words, he's being faced with a situation where they're not sure, could be 30, could be 45, and then it turns out it's 72. I don't know how that can be, knowing involuntary when you're faced with two choices, right? Or not choices, two outcomes, and then all of a sudden you get hit with a third.
But Your Honor, when
Help
they
me out with that.
when they keep saying these are preliminary
No,
estimates,
they said it one time. I have a transcript in front of me. One time, the prosecutor says, preliminarily, Judge, we have him at either 30 months or 45 months. One time he said preliminary.
Okay. Well, it is even saying it once, Your Honor. It's making clear this is an estimate. This is a guess.
It's an estimate. It could be 30, maybe it's 45. I mean, how does it end up being 72?
It's one or the other. He knows when he says, okay, I accept it, he knows it's either going to be 30 or 45. He's not knowing that it's going to be 72. Isn't that an entirely different thing? Well, I mean, would you accept your job if they said, look, we're going to pay you 30 or yeah, you would. Sorry. A bad analogy, but
No, if they said 72 or 45.
yeah, exactly.
And then they decided, oh no, it turns out it's going to be 30.
It's going to be 30.
Sure. It's a fair point here. It's a fair point. But again, our position, we believe that it was communicated that this was an estimate.
Understood.
And when you affirm under oath that you understand it's an estimate, you can't come back unsworn and say, oh, nope, actually, I didn't understand.
So you would have the standard be as long as prosecutors and defense counsel use the term estimate and preliminary when discussing numbers, then they're in a safe zone? Because isn't that what you're essentially establishing?
That is, that's how a lot of these pleas work, is they make it clear, we have preliminary estimates, but it could change at sentencing. And that's why so many of these Cobb's or Killebrews are to bottom of the guidelines as calculated at sentencing,
And you
because
think that that meets, just having that disclaimer in there meets the constitutional bare minimum
I
standard?
do, Your Honor. I do.
That's interesting because the word estimate doesn't appear in the transcript either. And the word approximate doesn't appear in the transcript. So I understand what you're saying is that's what was being communicated, maybe not those exact words, but just so we're clear, those two words weren't even used.
Fair enough, Your Honor. Any other questions?
No, thank you, counsel.
Thank you.
Thank you.
Thank you.
You have time for rebuttal?
I could just cite to page 6 of the plea transcript where the court specifically asks, is it true on or about November 2nd, 2015, in the Eastern District of Michigan, you were convicted of assault with a dangerous weapon and aid of racketeering? That's PRV 1. They knew it at the plea hearing. And PRV 7, we all know how to score that. So there's just no way to say, oh, something popped up we didn't know about. It was right there at the plea hearing. Thank you.
Well, they did. That is the hearing. The habitual, correct?
Absolutely.
So
So
that
you're.
didn't really, I mean, that was the purpose of that testimony.
I guess my point would be both the prosecutor and the defense attorney were on notice just from the felony information and the plea hearing alone. PRV 1 was going to be scored. There was no excuse to not score that. There's no excuse to not have the 72 months from the very initial scoring of guidelines. It's on the information. Thank you.
Thank you, counsel. That case is submitted.
Well done, by the way. Thank you both.
Now calling item number 19, case number 373427, People v. Norman Allen. Counsel, please approach.
Good morning, Your Honors.
Good morning.
My name is Jenna Cobb with the Michigan Innocence Clinic, and I'm appearing on behalf of defendant appellant Norman Allen. May I please reserve 5 minutes for rebuttal?
Absolutely.
I want to use my limited time here to emphasize how the trial court abused its discretion in denying Mr. Allen's motion for relief from judgment without even granting an evidentiary hearing. 24 years ago, he was wrongly convicted of second-degree murder for a shooting that occurred amid the chaos of a fight outside of a party house in the dark of night. And it's worth taking a moment to highlight here that this case is extreme, even in terms of other cases involving police misconduct. Multiple witnesses testified to the severe physical intimidation and torture that they endured while being interrogated by the police. Testimony that an officer repeatedly slapped a 16-year-old child, bent back a witness's finger until they impressed their pressure points until they agreed to implicate Mr. Allen. None of this was disputed. And some of this testimony was actually elicited at trial by the prosecution. In this type of case, where the reliability of the fact finding is already so compromised, the new evidence warrants the most serious consideration. At trial, with no physical evidence linking him to the crime, they relied on primarily on two witnesses' testimonies. One, Sally Jackson, who was the 16-year-old I mentioned. The other, Willie Perry, a man who did not know Mr. Allen. He had never met him before that night. He had been drinking and partying all day, was in the middle of a physical fight when the shots rang out, and his glasses had been knocked off his face. And that's the identification that they relied on. In the interest of time, I want to focus. Admittedly, we acknowledge this case is quite complex factually. There's multiple witnesses, a lot crowded scene. In the interest of time, I'll focus on the abuse of discretion in summarily dismissing two particular witnesses whose new evidence goes to the heart of the state's theory at trial. And that's first, Michael Boyd, the previously unknown eyewitness who identified another person as the shooter. And second, Sally Jackson, the 16-year-old child.
Counsel, if I could,
Sure.
Could you, before you get that, because those are two important things that we're looking at. Before you get there, could you talk a little bit about how the trial court applied the standards and whether or not what your view is on whether they, conflated the standards, on new evidence versus then weighing under the Crest factors
So with respect to a particular witness or just in general?
in general?
In general, there were not, the first step under Johnson is, a gatekeeping role of determining credibility, as you know. The trial court breezed through this without weighing credibility factors with respect to any witness. And then separately, the trial court abused its discretion by not taking together all of the new evidence to consider what the impact would be to a juror or to a jury composed of reasonable jurors who would be evaluating the case on retrial. Does that answer your question?
Yeah,
Okay.
yeah, yep, thank you.
No problem. As the court stated in Bacall earlier this year, an evidentiary hearing is appropriate on a claim of newly discovered evidence when defendant's offer of proof identified, if believed, would raise serious concerns about his conviction. That is this case. With respect to Michael Boyd, neither police nor counsel for Mr. Allen were able to identify all the people who were in the crowded house at the time of the shooting. Mr. Allen learned that years later, Boyd had not only been there, but he had seen the shooting and identified a specific person who, unlike Mr. Allen, actually had a motive to shoot at the man who was attacking his girlfriend. The trial court erred in saying that the account couldn't be new because he was present at the scene at the time the crime occurred. But by definition, an eyewitness will always be at the scene or near the scene when a crime occurs. And if that's the case, then a new eyewitness account could never be new evidence. That is not what the law intends. And then further, how could reasonable diligence demand that Mr. Allen, who was detained pre-trial, locked up, identify people who the police's own investigation, however problematic in this case, was unable to uncover? I mean, they were literally rounding people up, torturing people, and still didn't get the information that Mr. Boyd was in the house. Separately, if the court was going to decide that Michael Boyd was not new evidence, his account was not new evidence, once it denied that Crest claim, the court was then required to consider Mr. Allen's alternate claim of ineffective assistance of counsel. Not even addressing or acknowledging that claim falls outside of the range of reasonable and principled outcomes within the trial court's discretion. And that alone would be enough to reverse the trial court. Then I want to touch briefly on Sally Jackson, the other witness. As Mr. Allen proffered, as your honors know from the briefing, several pieces of new evidence. And the trial court dismissed Sally Jackson as not new and not credible summarily. There's no categorical bar on recantations. In fact, in Johnson, Michigan Supreme Court, and Bacall, this court, they're both examples of cases in which the courts accepted recantations as new evidence and ultimately overturned the convictions. With respect to the credibility determination, the trial court did the exact thing that Johnson prohibits, which is substituting its own judgment or his own judgment for that of a reasonable juror in direct opposition to Johnson. As I mentioned at this stage, the trial court is not the ultimate fact finder. And so the question is not whether the trial judge himself, who in this case had not even seen the witnesses to judge their credibility, would credit the witness's testimony. The trial court must consider whether, in light of all relevant factors that would both bolster or diminish the veracity of the testimony, a reasonable juror could find the testimony credible on retrial. Again, here the answer is yes. The recantation is supported by the record. Multiple witnesses testified in ways that corroborate Ms. Jackson's account of what occurred. And she, then still a child herself, had been tortured into providing this information. So the idea that she would, now that she's an adult and many years later, back away from that, a reasonable juror could credit and understand why someone would do that. I also want to speak very briefly about Officer Hughes, the officer in this case. The claims of his abuse are corroborated by other new evidence. We have the affidavit of Mr. Legion that indicates that Officer Hughes's investigative tactics demonstrate a plan, a scheme, a system to abuse, to use untruthfulness, to coerce in order to secure convictions, and more specifically in these cases, wrongful convictions. Because, just returning back to Ms. Jackson, because her recantation is not patently incredible, and because if it was believed, it would raise serious concerns about the conviction, the trial court abused its discretion by denying without even addressing the issues of newness and credibility in a way that comports with Michigan law. Finally, the trial court abused its discretion by offering a very cursory treatment of the new evidence in fragments. Once that low gatekeeping threshold for credibility has been met by the trial court, with respect to a single piece of evidence, the trial court then has to take all of the evidence together to see what would a reasonable jury make of this at a new trial. A jury today will be presented with a fundamentally different case than what the court heard in 2001. They'd hear from at least 4 people who would unequivocally say that Mr. Allen was inside the house the moment the fatal shots were fired outside. They'd hear about the insidious police abuse that took place, corroborated by more evidence since of Officer Hughes' systematic practice of manipulating investigations to secure convictions. They'd be presented with a named alternate suspect, identified by eyewitnesses, and hear of his motive to shoot the victim in this case. And the state's case would rest on a single eyewitness who'd spent the day drinking and partying, again, was at the center of a fight with multiple people when the shots rang out, during which his glasses were knocked off, looking at people he did not know in the dark of night. On these facts, a reasonable juror could readily decline to find guilt beyond a reasonable doubt. So in conclusion, any one of these pieces of new evidence would independently warrant a new trial. But taking it all together as required by Johnson, denying him even an evidentiary hearing falls far outside the range of principled and reasonable outcomes in this case. And for that reason, we respectfully ask this court to reverse and remand for an evidentiary hearing.
Thank you, counsel. Very well done. Any questions?
No.
No questions.
Actually, I do have one.
Oh.
How do you respond to the prosecution's argument that this wasn't new evidence, that it was discoverable or otherwise available in one form or another before the successive motion was filed?
Now, are you speaking specifically to Michael Boyd, Sally Jackson, or something else? I'm happy to address all of it.
Both, yes.
Okay, so with respect to Michael Boyd, the prosecution's presuming that Mr. Allen knew he was there. Nothing in the record supports that. Mr. Boyd doesn't say that. We know he, in fact, didn't know he was there. In fact, he would have loved to have known he was there and what he saw at the time. People weren't running to bring their accounts of what happened. And when you see what happened with the police misconduct in this case, I could see why people wouldn't voluntarily go and subject themselves to that, or themselves be possibly blamed for the crime. So I say all that to say there's nothing indicating that Mr. Allen knew that Mr. Boyd was in the house. There were 30 people in the house. It was quite crowded, partying, people coming and going. So there was just really no, and again, I will rely on the fact that neither counsel nor the police found Mr. Boyd or knew that he was there. With respect to Ms. Jackson, hers is a recantation. So she's literally providing new evidence in the sense that she's saying what I said before, that Mr. Allen was the shooter, that's not true. That is not something Mr. Allen could have presented prior to, at the time of trial or prior to his earlier motion for relief from judgment. And would you like me to go through any other? No, okay.
Thank you, counsel. Very well argued.
Thank you.
Good morning, Your Honors. My name is Joseph Schaap. I'm appearing today on behalf of the people. I think for the most part, the briefs pretty much laid out the issues. Obviously, there was quite a bit of briefing in this case.
Can you start? I'm sorry to just jump on you right when you get up there, but can you start with your position on whether or not the court applied the right test and walk through the correct procedure?
So,
Because that, to me, I'm really troubled by how the court applied the correct procedural tests to the evidence that was presented in the successive motion.
Understood. So it's a little bit of a complicated question, just insofar as when you combine the 4-factor Crest test plus adding in the procedural rules of the 6,500 rules, obviously there's a lot of different facets of this test.
Right, but they're
Um,
important to do it. You would agree that it's important that they're evaluated in the right steps at the right time, would you not?
To an extent, of course, ideally, yes, I would agree with that.
Okay.
I think that there certainly is, even if the court made certain mistakes in the reasoning, this court could still affirm basically on the right result, wrong rationale sort of reasoning. So I don't think it's necessarily dispositive if the court made some sort of stumble so long as the result in the end was correct. But I would agree ideally that you would want to follow the 4 prongs of Crest plus the additional
Well, where would we start though? Wouldn't we start with 502?
502, yes.
Start
So
with that.
502 basically says new evidence or retroactive change of a law to get successive motion filed. I think the court did misstate the holding of this court. Actually, I think it was the Supreme Court in Swain that Crest doesn't apply to 6502 claims. I don't know if it was necessarily a misreasoning on the court's part so much as it's just a misstatement, because the Swain court basically said that the Crest factors don't apply to the threshold question under 6502, but then once you get past 6502, Crest does apply. And it does seem, if you go further in the court's opinion, that the court is applying the Crest test. I think it might have just maybe misstated in that particular sentence what it was trying to say, which is that Crest doesn't apply to that little threshold question.
If it's unclear in the transcript, is that enough for us to say, look, you got to go back and do it the right way?
I don't necessarily think so, just as I said earlier.
Why not?
Because basically, I think this court could still analyze the case itself and say, okay, the court may have had some kind of preliminary mistake in its reasoning process, but it still reached the correct result. So it could affirm under the right result, wrong reasoning sort of.
So just so we're clear, you would agree, though, that the transcript is unclear at best on whether or not the court addressed 502 first before going to the second step and looking at the Crest factor.
So partially yes and partially no. So I don't think the court actually has to apply 6502 first. I think that's the easiest and most straightforward way of
Isn't that what our
analyzing it.
Supreme Court dictates?
Well, I think the court could, I guess the analogy I'd make is a Strickland claim. Let's suppose, and I think it's actually in the Strickland opinion, but just hypothetically, suppose a court thought, okay, I could decide the deficient performance question, but it's obvious to me that there's no prejudice, so I'm just going to decide that and not decide the deficient performance question. I think the court could say this hypothetically, I think the merits of this claim that's raised in a successive motion fully from judgment are just not there. So I don't need to even get into the procedural bar question of 6502 or 6508, just because it's clear to me that even if this was raised on direct appeal, this would fail.
But then none of that's in the transcript, though. We would have to guess and read that into the court's thinking.
Well, I think
Because the court, in this case, misstated a fundamental tenet of law about the application of the Crest factors. And we're to ignore that and just assume what was in the court's thinking?
I don't think it's an assumption without any basis, because as I mentioned, as you get further into the court's order, it does apply the Crest factors. It just doesn't, like at that first sentence at the very beginning, I would agree is wrong. But I think it was just a misstatement as opposed to a misreasoning on the court's part, because the court does in fact apply the Crest factors to the various witnesses as it goes further in its opinion. And then secondly, as I mentioned earlier,
So is your position then none of I think there were 5 total discrete pieces of new evidence. Is your position that none of those constitute new evidence?
Just
Even the
one.
just one?
Just Jackson. So, and I could go into any of the other witnesses that the court wishes me to go into.
Okay, so Jackson, your position is Jackson doesn't constitute.
Jackson does.
Jackson does. I'm sorry, does, but the rest do not.
The rest do not. So there was 11. I understand that the defense isn't necessarily claiming that all of them are newly discovered, but I'll just go through them very briefly. Boyd in particular, I would say is not newly discovered. And I understand counsel's point about just the fact that he was present doesn't necessarily mean it couldn't possibly be newly discovered.
I'd like to go back to that in a minute, but before you do that, so if you concede that Jackson is newly discovered evidence, past tense,
Yes.
doesn't that meet the threshold of 502?
Yes. just to get consideration gets past 6502G. I would agree.
What's supposed to be the next step?
So then you go to 6508D, which is good cause and prejudice. And basically I would suggest,
I mean, procedurally, like what kind of, is it something the judge can just do sua sponte, or is the defendant entitled to a hearing?
I don't think
Talk about that.
you mean an evidentiary hearing.
Or even any kind, yeah. I mean, obviously that would be the gold standard, but even a court hearing without taking evidence.
No, I would not say that they're entitled to that. There's case law saying that basically the court has discretion on whether they want to order oral argument or an evidentiary hearing. So the court in this case obviously decided it on the briefs. But it would have to be an abuse of discretion to not order the hearing for the court to reverse that determination. And I think that's either in 6.508 or maybe one of the earlier 6500 rules that says basically the court has discretion over whether to order oral argument, whether to appoint counsel, et cetera. So I don't think procedurally the court has to do any of those things. It's just a matter of the court's discretion. That being said,
I didn't mean to take you off track. Go ahead.
Understood. So basically just to stick with your line of reasoning though. So 6502G is the first threshold question for a successive motion free from judgment. Then you get to 6.508D, which is the procedural bars that apply to all motions free from judgment. And in the context of a newly discovered evidence claim, that's basically the CREST test. So that would be, I think, the most straightforward way of reasoning it. But as I mentioned earlier, I think the court could just say this claim fails under CREST. Therefore, I don't even need to get into the procedural bars because the CREST test is obviously not satisfied. in my
So your
opinion.
position would just be that courts can assume that all of that is new evidence and then go to the CREST factors.
Yes. I think if the court finds that, because CREST also applies if you raise a newly discovered evidence on claim on direct appeal.
Right.
And I think CREST itself actually was a direct appeal case. And so the court could just say, okay, this claim, whether it's CREST or not, it could be a Miranda claim or whatever. It's obviously unmeritorious to me. Therefore, I don't need to get into all these 6,500 rules because no matter when this had been raised, it would have failed. I think a
We'd
court could
expect
do
the
that.
court to state that on the record somewhere, right? They have the court state, I find that the threshold has been reached under 502, but because of 508, I find relief is not granted or something along those lines.
In a perfect world, I would agree with that. I don't think the court necessarily has to make it that explicit.
So I guess where I'm troubled with is that what you're suggesting then is essentially we just ignore those procedural hurdles or requirements that the rules mandate and just go to the CREST factors. Why don't we just have the CREST factors?
Well, I don't
Why
think-
have those procedural hurdles to begin with?
So I agree with you, and I think the procedural hurdles are very important. I just don't think that a court, if it's denying the motion for relief from judgment, needs to go through them every time. If it thinks that the merits of the claim are clearly unmeritorious, then I don't think the opinion of the court has to literally go through them all every single time. I think as long as, if it's granting the motion, then I
Isn't
think,
that a slippery slope?
I guess I don't understand.
I guess if the trial courts have discretion of, look, if I just get to the right result, why do I have to go through all the procedures?
Well, I think the court obviously should reason it correctly. I would not dispute that as a matter of best practice. But I think as far as this court reversing, obviously this court is reviewing this case as an appellate court trying to see if there's reversible error in this case. I don't think it's reversible error if the court reaches the right result for the wrong reason. And of course, I don't think there's any allegation in this case that the trial court somehow purposely made this mistake just as a matter of laziness or whatever. I think, as I mentioned with the 6502G point in particular, I think it was just maybe an inartful phrase of what he meant to say. I think he was meaning to say the Swain point, which is new evidence claims gets past the threshold, but he just stated it inartfully. But that being said, as I've already stated, I think the court reached the right results under the CREST factor. So therefore the court can affirm for kind of a right result, wrong reasoning sort of analysis.
Understand your position. Are there any other points you want to make for us to consider before?
Yes, I'll just go briefly through which witnesses are newly discovered and which ones are not.
Okay.
So Jackson, I think there's and it's only a portion of Jackson's affidavit that's newly discovered. Most of her affidavit is actually consistent with how she testified at trial. And I think it's been kind of lost in the defense analysis that all these allegations of police misconduct, which just as an aside, the counsel said they were non-disputed. I don't agree with that. We are not conceding that any of this abuse actually took place. But that being said, this was all before the trial court at trial. The only difference as far as that allegations were concerned is the name of the officer that supposedly did the abuse. I don't see how that's particularly relevant.
So clarify that point. So you're saying that at trial, it was one officer that they thought they engaged in abuse and now it's a different officer?
They just didn't name the officer at trial.
Oh, they
So
didn't.
basically, God bless you. Basically at trial, Miss Jackson just said an officer, I think she actually said two officers did such and such to me. And I think she actually made it quite clear at trial that even though all this happened, what I'm saying here, inculpating this defendant, is still true. And this is not affecting my testimony. This is all before the trial court at the time of trial. So there's three portions of her testimony that are, or her affidavit, excuse me, that are newly discovered. One is this part where she changes her opinion on who the shooter was. That's obviously the recantation portion. Then the naming of the officer who did supposedly abuse her. And then the third is the allegation she brought up in the Hamilton case, basically that she made the exact same claim against Officer Hughes in the Hamilton case. And obviously, the Hamilton case is collateral to where we are in this case, so I don't want to go too much into the nitty-gritty of that case. However, I think that case actually helps our position that she's not credible in recanting, because not only did the circuit court and then this court reject the claim in Hamilton that Miss Jackson, or the defendant, raised via Miss Jackson, her claims of abuse against Officer Hughes in the Hamilton case are even more provably false than they are here, because basically she made the same sort of claim in Hamilton that, Investigator Hughes beat me, and that's why I inculpated Mr. Hamilton. But in that case, Miss Jackson there was a 911 call from the scene of a shooting. Another officer other than Investigator Hughes responded to the 911 call. Miss Jackson was still present at the scene, and she named the defendant, Mr. Hamilton, in that case to that officer before Investigator Hughes was even involved in the case at all. So like her allegations that the only reason in that case she named the defendant was because of Officer Hughes's supposed misconduct is provably false. So that, of course, greatly, casts doubt on her claims, similar claims to that effect in this case. That being said, her naming of the officer is new. Her recantation of her testimony against the defendant is new. And then the Hamilton, I guess you call it 404B evidence, is new. The rest of her affidavit, on the other hand, as far as the sequence of events of the shooting, is consistent with what she said at trial. So that's not new. Then going to Mr. Boyd, under Mr. Boyd's own words, he was present at the scene of the shooting on Lothrop Street for hours on the date in question, and he was in the same room with defendant at the time of the shooting. I can't think of a more case where this is either not newly discovered or it's not reasonable diligence on defendant's part to raise Mr. Boyd as a trial witness. There's basically only two possibilities with regard to Mr. Boyd and Mr. Allen's supposed lack of knowledge of him. Either Mr. Allen knew he was there, which I think is the most likely scenario if he was in the room with him, and Mr. Boyd was there at the house for hours. It seems highly unlikely that Mr. Allen could have failed to notice him. That's number one. And then number two, even if
Weren't there a lot of people in the house?
So the defense says there was 25. I don't recall that being the testimony. I think there was probably about a dozen. There was never an exact count as far as I can recall at the trial of how many people were there.
But
There
even,
was several.
even if it's between a dozen and 25 in a house and it's a house party and all that, is it not unreasonable that somebody was in one part of the house and didn't see somebody else in another part of the house?
So that Mr. Boyd, according to Mr. Boyd, they were in the same room. So that's obviously a different thing than being in different rooms in the same house.
Right,
So that gets my second point. The first point, of course, would be because they were in the same room, Mr. Allen would have known that Mr. Boyd was there. The second is that even if he didn't somehow did not know that Mr. Boyd was there, he knew, and this is clear from the trial record where Mr. Davis's name is mentioned, he knew Mr. Davis was there, and Mr. Boyd states that Mr. Davis knew he was there. So therefore, reasonable diligence, if Mr. Allen was investigating his case thoroughly, he could have, if he didn't know who else was present at the time of the scene, he should have asked Mr. Davis, who he knew was at the party. Hey, Mr. Davis, I think his name is Marcus. Hey, Marcus, who else was there that day? And Mr. Davis knew that Boyd was there, so he could have told him, oh yeah, Mr. Boyd was there. But Mr. Allen failed to do this, so his investigation was not reasonably diligent. So either way, basically, the defense or Mr. Boyd's affidavit fails on the preliminary prongs of press. Either he knew Mr. Boyd was there, in which case he fails prong one, that it's not in fact newly discovered. Or even if he somehow didn't know, he wasn't reasonably diligent in his investigation to figure out that he was there. And so therefore it fails under prong three.
Understood.
And then the rest of the evidence, I won't go through all of them, but basically most of it is inadmissible. Like there's the affidavit from Miss Sanford that's just clearly hearsay. There's the polygraph results, which is inadmissible by statute. The two witnesses who are deceased obviously won't be testifying at trial. And I mean, I could go on and on. Mr. Davis, who filed an affidavit, he was mentioned repeatedly at trial. The same thing with Miss Walker, Miss Hill. So
Yeah, and those are all that's summarized in your briefing.
yes,
is that
so I
correct?
won't go
Yeah.
through all of them. And the last thing I wanted to mention is the Anthony Legion affidavit. And I mentioned 3 or 4 different reasons why I thought this would not be admissible. But the one I want to focus on is the Craighead sort of reasoning of, oh, this could come in as sort of either 404B evidence or impeachment evidence. Well, it couldn't be impeachment evidence because investigator Hughes did not testify in this case. So who is there to impeach? But secondly, as far as it being 404B evidence, Craighead involved an officer who allegedly was basically coercing false confessions. And there was a very particular pattern of her false confession eliciting, supposedly. So there was a very, and I think the case law uses the term striking similarity of her misconduct. Here, the allegations against investigator Hughes in this case, which involve, physically attacking witnesses, do not even resemble in any regard at all the allegations that Mr. Legion raised against him, which is basically a Brady violation. These are 2 completely different supposed acts of police misconduct on investigator Hughes's part. So this is just classic propensity evidence. The only reason that this evidence could possibly be admitted by a defense attorney at trial would be to smear the officer as just a quote unquote bad police officer. And that is not admissible under 404B. That's classic propensity evidence. And so therefore all the Legion case details would not be admissible in this case at a potential retrial at all. That being said, unless the court has further questions, I will stand on the brief. Obviously the briefs are quite lengthy.
Any further questions?
Oh, thank you.
No,
Thank you.
thank you,
Thank you.
counsel. Counsel for appellant?
Thank you. I first want to clarify the point about the state's position with regard to the police misconduct at trial. I understand the state's now saying they don't concede that. At the time of trial, they very much did. And just as one example, a 15-year-old witness who had been subject to their misconduct, let's say, was testifying. The defense attorney was doing cross-examination. The state objects and says, quote, "What difference does it make if he beat it out of her?" End quote. That is only one. There were other witnesses where he asked, used euphemisms. They were harsh. They were inappropriate. I don't remember the other quotes and I don't want to misquote it, but it was clearly accepted. They did not contest in the least that this happened. In fact, they elicited it. And just in connection with that, with respect to Anthony Legion, yes, Mr. Hughes did not testify at trial. I presume that had a lot to do with his conduct, given his involvement in the investigation. But certainly he could be called in the future and impeached. He's very much relevant and material to this case. And also it impeaches the investigation when you have misconduct of this magnitude. I won't get too much into the procedure. It's obviously not only a best practice issue, it's the law and what's required. And the state is now saying, yes, we say Jackson is new. Under that alone means that under 6508D3 and as applied in Johnson and Bacall, having one piece of new evidence is enough that now the next step would be to consider the impact of all of the evidence in the record. Old trial, what would come up at a new trial, things that are helpful for Mr. Allen, things that look awful for the state, all of that needs to be considered together at this point because there's no question that there is new evidence. I won't address Mr. Hamilton's case because it's a completely different case and this is such a factual inquiry. So I don't want to speak to his case. I'm not counsel there. My understanding is there's no evidentiary hearing there either, but I will limit my comments to that. And the court can clearly, in the context of evidentiary hearings, in the context of deciding whether someone gets a new trial, consider things that would not be admissible at trial. The rules anticipate that by saying, look, the rules of evidence don't apply. It's privilege. We have other cases like polygraphs, not admissible normally, but you can use them to corroborate. So there's always affidavits is always intended for us to look at a more wholesome picture or more fulsome picture than what the jury would eventually get. And we're saying again on retrial, obviously it would again be the state's burden. And so we're saying, would a reasonable juror look at this? And is there a reasonable likelihood that a different result would happen and that they would be able to see that the state cannot prove a case beyond a reasonable doubt? So if there are no other questions, I will stop there.
I have the same question for you as I asked Mr. Shoup about procedure. So again, assume there's one new piece of evidence, which is Ms. Jackson beats the threshold of 502. What's the procedural requirement of the court at that point? Whether it be an evidentiary hearing, a hearing, or no requirement for a hearing at all?
So it depends on what the new evidence is. We're not suggesting that there couldn't be a case where new evidence was put forward that was completely incredible, that defied the laws of physics, as someone else said. We're not saying that in all of those cases you would have to get a hearing. What we are saying is at that point, there is that threshold credibility finding, which is, again, just low gatekeeping role of whether this is such that could go to a jury. And before you say, no, this cannot, you do have to have an evidentiary hearing. It does have to be taken seriously.
Thank you.
Thank you.
Thank you.
Anything else?
No.
Thank you, counsel.
Thank you.
Very well argued. That case is submitted. Calling item 20, case number 372254, JL v. Natasha McGee. Counsel, please approach and state your appearances on the record.
Morning, Your Honors. Admiral Altwheel. May it please the court, Admiral Altwheel, on behalf of plaintiff. We ask that this court deny the defendant's appeal and affirm the lower court's decision holding that at minimum, genuine questions of material fact exist as to whether defendant appellant is grossly negligent. Gross negligence is defined under the Governmental Tort Liability Act as conduct so reckless as demonstrates a substantial lack of concern that injury would result. Further, under 691-1407 subsection 2, there's a proximate cause analysis as well. Proximate cause here has two prongs. One being the actual causation and the other being legal causation. There are
Let's
two
talk
separate.
about the legal causation because this is a governmental immunity case and we have to look at the proximate cause, right? So can you give me your argument for how the principal's conduct was the one most immediate, efficient, and direct cause of the injury here?
Absolutely. So, but for the negligent retaining of an untrained, uncertified, and unqualified teacher, these actions would not have resulted in plaintiff's harm.
How is that different than regular causation, right? That I can see that being a proximate cause, but how is that the one most immediate, efficient, and direct cause?
Well, with intentional torts, it seems to break the chain of causation. However, under a gross negligence analysis, we believe that the potential would be the actual retainment or the hiring of an uncertified, untrained, and unqualified teacher. A recklessly indifferent principal who hired this untrained, unqualified, and admittedly incompetent teacher to handle a classroom full of students with special needs resulted in plaintiff's harm. And this is the
But is
proximate
it,
causation.
isn't the direct, I mean, we don't look at what sort of the beginning of, doesn't the law require us to look at what happened exactly the moment sort of before the injury, not what happened months before the injury happened?
Well, there's two separate tests for the proximate causation. One is the actual causation that we spoke about. Well, actually the legal causation, but there's also the actual causation, and under the foreseeability test, it's reasonably foreseeable that by hiring an untrained, unqualified, and admittedly incompetent teacher, that an injury would result because the teacher could not handle a special needs classroom. By allowing this to happen, subsequently, the results would ended in an injury. And
Tell us where in your complaint it alleges that the teacher was untrained or unqualified.
well, specifically, in the brief on appeal,
Oh, in the complaint that was filed in this case that started your cause of action.
so we were not allowed discovery to gain any information relevant to the claim. However, through defendant's answer, motion and summary disposition in lieu of the answer, they provided an affidavit where the teacher specifically said, I, teacher, was not even certified to be a lead teacher in the classroom. I was hired as a substitute teacher and principal made me the gym teacher.
Then move to amend your complaint? Or I'm sorry, did your client's counsel move to amend the complaint?
But we did not even have an opportunity to amend the complaint because defendant appellant immediately filed a motion for stay and appealed the case.
In response to that motion for disposition, you had to appeal it.
Not specifically, because technically the trial court agreed that genuine issues of material fact existed.
Oh, I mean, in your response to the motion for summary disposition, did you say, oh, Judge, we disagree with this motion, but by the way, you don't think our pleadings are succinct enough, let us file an amended complaint?
Not specifically, however, this was argued again on appeal, and we did put the transcript of the court record where the trial court held their findings, and among many questions of fact in this case that the judge ruled was whether the principal was grossly negligent when it comes to hiring staff at a special needs academy. Another question that the court presented was, did the defendant teacher approach defendant principal on numerous occasions to indicate that she's not able to handle these students? So several questions of material fact exist with regard to this.
Counsel, would you agree that under the governmental immunity statute that the gross negligence is a high standard to have to get around? Would you agree with that?
Absolutely, yes. And to explain the specific reasons why plaintiff appellee believes that this recklessly indifferent principal was grossly negligent, specifically because the principal was approached by the teacher at least on one occasion that plaintiff appellee is aware of, and specifically the principal said, deal with it. And this was in response to whether.
Teacher or a different teacher?
Correct, same teacher.
Was it the same student?
What was that?
Was it the same student?
Correct. Well, it dealt with the classroom.
Okay, but not the student in particular.
Correct. The
Okay.
student was in the classroom. However, this particular teacher who was unqualified, uncertified, untrained, hired by this recklessly indifferent principal, and admittedly incompetent teacher came to the principal stating that I cannot handle this class.
Okay, but isn't that different than, is it the act of hiring, or is it at that point the gross negligence arose?
So
Is that the most direct result, or was it the hiring? At what point? Do you understand what I'm saying?
Exactly, Your Honor. And further discovery is required in order for us to determine when the exact moment of gross negligence occurred with regard to the hiring, retention, training, or supervision of this particular teacher. It might have occurred because the principal did not check the background qualifications, certifications, specifically for special needs students. And essentially, it could have occurred then, or it could have occurred when she approached the principal and stated specifically, I cannot handle this classroom.
Okay, I think we understand your position. Any further questions?
So,
Any other final points you want to make?
yeah, so one other point is, with regard to a case that defendant appellant cited, which is, Oliver v. Smith in their, appellate brief. It has nothing to do with schools, however, defines gross negligence in the context of proximate cause. And this court specifically said, or held, I should say, that the defendant may possibly or potentially be entitled to summary disposition, granted that discovery be completed. And here, discovery has not even been able to be conducted because the defendant appellant filed a motion for summary disposition in lieu of an answer. So therefore, we just request that that this court deny the defendant appellant's appeal in its entirety, affirm the trial court's decision holding genuine questions of material fact exist with regard to whether the principal was grossly negligent, award any costs and any other relief as justice so requires.
Thank you, counsel.
Thank you.
That case is submitted. And calling our last case on the 10 o'clock call. Item number 21, case number 371-573, member select insurance v. Dominic Frazier. Counsel, please approach and state your appearances for the record.
Good morning, Your Honors. I'm Grant Jaskulski on behalf of Member Select. And may it please the court. Try to keep it short because I think this it's been thoroughly briefed by both sides. Obviously, this case hinges on what does the term domicile mean in this insurance contract. As we have maintained, and as this court or as the Supreme Court has held, domicile has a precise legal meaning. I don't think there's any dispute there. I also don't think there's any dispute that the defendant here was not domiciled at the insurance household. He remained domiciled with his father under Grange because of the custody.
How do you address the opposing counsel's argument that Grange is inapplicable because that dealt with the No Fault Act and interpretation of the term under the No Fault Act as opposed to as a legal term?
Well, the same construction principles apply between contracts and statutes. If a contract uses a precise legal term, just as a statute uses a precise legal term, it should be afforded that precise legal definition. Here, the contract used the precise legal term domicile, just as the statute did. That was at issue in Grange, so it should be afforded the same precise legal definition. And even if it's an insurance contract, it's also construed as the same way because insurance contracts under Rory versus Continental are just like any other contracts.
Yes, my apologies.
No worries at all. And yeah, the same exact reasoning from Grange applies to this because a term in a contract that has a precise legal meaning must be given that precise legal meaning, just as was the case under Grange in the No Fault Act.
Was this claim ever tendered to farmers? And if so, did they refuse to take it?
I believe that would be a better question for opposing counsel. But I'm not exactly,
Good.
but yeah, I'm not sure exactly there.
Any other questions?
No.
Thank you, counsel. Well briefed.
Thank you.
Morning, Your Honors. My name is Daniel James. I represent the defendant Dominic Frazier.
AAA ever tendered the claim to farmers?
Yeah,
If you know,
yes.
and farmers
is
denied
paying-
the tender, correct?
No. What happened was, member select AAA paid for the damage to the house. They sued Dominic Frazier for.
Well, that's what I meant. I meant,
Right.
it's instead of paying for the damage to the house, did member select ever contact farmers and say, we're tendering this claim to you under a subrogation theory? If you don't know the answer, that's.
I don't know what happened pre-suit,
Okay, that's
but,
fine.
or whether there was any sort of discussion like that. But yes, Farmers is Dominic's father's insurance company. And Farmers has provided Dominic with a defense throughout this case. But getting to the issues here, I disagree that the analysis in interpreting this homeowner's policy is that if you get to a word in the policy that is not defined, you immediately jump to some, as the Grange Court said, precise technical meaning of the term domicile, and then interpret this homeowner's policy to have that meaning. Instead, what the courts have said throughout Michigan jurisprudence is that the technical constructions are not favored. And that, so we have Grange saying the definition of domicile we are giving to that word in the No Fault Act is a precise technical meaning. And yet, on the other hand, we have these other cases that say when you construe a contract, you don't look to the technical meaning. You look to the ordinary meaning, the common meaning, the plain meaning of the word. And so, and the Rory case says that when you have a policy, and in Rory it was UM/UIM coverage, but you have a policy that is not controlled by a statute like the No Fault Act, you construe the statute without reference to the No Fault Act. So I don't think we have to deal with what the court
Do we
said.
have to reference the No Fault Act to understand the meaning of domicile? I feel like a lot of the case law and analysis in Grange dealt with interpreting the term domicile without reference to the No Fault Act at all, because it wasn't defined in the No Fault Act, right? So they were trying to figure out, what does this term mean?
Correct.
How is that analysis different?
So when the interpreting a statute, they do allow, when the legislature uses a term that has a precise legal meaning, that is the legal meaning given to the word in the statute. That's not the same for a homeowner's policy.
What about the common law? What if the common law has a recognized legal meaning for a term?
Well, the way the courts have said to interpret statutes is their plain, their ordinary, their common meaning. And what courts have routinely done when interpreting insurance policies, and they get to a word and it's not defined in the policy, is they go to a dictionary and they look up the word in the dictionary and they give it its plain meaning. And that's what we proposed in the lower court. That's what we are saying is the correct
So if
analysis.
that dictionary definition is completely contradicted by the common law definition, we're supposed to go with the dictionary instead of our own published precedent, right?
I think that is the appropriate case. And I cited a couple cases for the court in our brief. The McCusick case. In that case, it was a CGL policy. And the issue was whether a pollution exclusion applied. And in that case, the insured argued that the type of pollution at issue wasn't what you'd normally think of as pollution. And that you had to read it with this gloss of, what do we think pollution is? And in that case, the court said, no, we are not going to interpret this pollution exclusion in regards to environmental terms of art to interpret the words discharge, dispersal, release, escape. Instead, and this is what the insurance company argued, you have to apply the plain and ordinary meaning of those terms, not what they mean in the industry, but their plain and ordinary meaning. And so in that case, they said the type of pollution in that case, it was discharged, dispersed, released, escaped, one of those under the plain and ordinary meaning, even if not.
But my question to you wasn't about industry jargon. It was about published precedent of the Michigan Supreme Court or this court. We previously defined a term under the common law,
Sure,
and we're looking at that term in a contract. I
sure.
think what you're telling me is we should disregard our published decisions and go to Webster's dictionary.
Well, let me get to my second case, the groom case,
Okay.
Your Honor. Because in that case,
Can be homeowners, right?
yes, and
Non-public.
it is unpublished, Your Honor, but they applied a similar analysis as in McCusick, which was they were trying to figure out what the word costs meant in an insurance policy, because attorney fees had been assessed against the insured in that case, and they were looking for coverage for them. And they said, these attorney fees are covered costs. And the court said, yes, we understand that the word costs within the law does not include attorney fees. Those are two separate things. But when we look at the plain, the ordinary, the common meaning of the word costs, attorney fees are costs and they're covered. So I think that's an example where there was a well-established legal meaning of a word costs in groom. And the court said, we're not going to apply that meaning because the plain meaning is different, and it's the plain meaning that controls in an insurance policy. And again, under the theory Member Select is proposing, their insured, Dominic's grandma, gets a policy, and the law presumes she reads it. And she gets the word domicile, and she wonders, what does domicile mean? And she punches it into her phone, domicile definition, goes to Merriam-Webster. There's two definitions. The number one definition is residence, a place of residence. Number two does say law, and it's more in line with Michigan jurisprudence and their interpretation of what domicile means from a legal perspective. But the number one definition on the list is place of residence. So are we to expect?
But
Oh,
Yeah.
I'm sorry, go ahead.
Sorry, I just put it into Google.
Yeah.
And it's what you've recommended. It said domicile is a person's permanent legal home, which is the place that they have lived and intend to return to indefinitely. It is distinct from residence, which is a more temporary and current living situation.
So I looked up domicile on Merriam-Webster.
I
this
didn't
morning.
go to Merriam-Webster. I
Okay.
went to Google.
That may
and
be,
that is the
that may
first
be where
definition that
we're
it
differing.
filled up.
I took a screenshot.
So then how is a
of it.
court supposed to interpret it
Well,
your argument is that we're supposed to look at the plain and ordinary meaning of
Yeah.
this term?
sure.
And I think that one of the things that we have grappled with as the bench and bar is that when you're dealing with a dictionary, you're dealing with a range of definitions.
Sure.
And sometimes there's definition shopping, you're trying to figure
Sure.
out which definition fits
Sure.
the best. And depending on what your argument is, it's going, and so I didn't go to any specific dictionary. I used Google, which is kind of widely recognized as a way of getting very broad, maybe
I prefer
plain
Bing.
and-
Bing
Bing.
gets me more favorable definitions.
Probably the plain and ordinary,
Excuse me.
if we're gonna argue the plain and ordinary, that is the definition that just pulled up. Now, I don't know, maybe if I did it a day later or a year earlier, the definition would be different. But when we're talking about a canon of how this court or the Supreme Court is supposed to interpret language, how does that inform the inquiry?
Well, the reason I focus on Merriam-Webster and one of the other definitions and not just the Google or the AI, as it often is now, response up at the top is because in the insurance cases, when they look at the dictionary, they cite to a dictionary. They don't just Google the word and then, cite Google, they cite
But
Merriam-Webster.
were you,
Yeah, I'm just saying, I employed online dictionaries.
because
But
the scenario you brought up was the insured looking it up and seeing,
Yeah,
well,
right.
when I have
So-
this, what does it mean?
so, like I said, on Merriam-Webster, number one was place of residence. Number two was more in line with what you found on on.
So do we have
on
to
Google.
change the
well-
analysis? Like, right, because, I mean, going to more of a philosophical
Sure.
maybe discussion, if we were relying on a dictionary, maybe in a different era when Google or Bing was not readily available, and that a dictionary was a way that the plain and ordinary person would figure out what a term meant, do we need to now look at our case law and say, okay, does that shift now? Because now people, the way people are accessing what the plain and ordinary meaning of a term is, has shifted. Is that something that we need to be introducing into our lexicon?
Good. I mean, these are all good questions because this really does come down to, how are we going to interpret words and the way searches have evolved and how information is gathered. I think the answer is that, look, there's a couple different principles that indicate that a tie here goes to Dominic Frazier. And the first is the pretty well-established insurance principles about construing policies in favor of coverage. And that's what, I mean, we're talking about determining that he is an insured person and that he would therefore be covered under that policy, and that's why they cannot sue him. So there's that principle of construing that definition broadly in favor of coverage. The second principle that indicates if we think it's a tie, because even under the Merriam-Webster, you got one, you got two. Which one is it? Which one is it? If it's the ambiguity law, because if a policy can be interpreted reasonably.
What about the canon that we look to our precedent and look to how the term has been used in our case law?
Well, again, I think the reason why it's important to focus on what's readily available to the public, because again, she doesn't go onto Westlaw and look up Grange and look up Michigan jurisprudence. She goes to the resources that are readily available to her. And here it's a little bit of a mixed bag. You get a couple different definitions, one of which is residence, one of which is the more stringent legal requirement. So which one is it as she's sitting there trying to figure this out?
Well, let's get back to contract principles.
Sure.
So one of our rules is, when we're interpreting a contract, we need to give meaning to every word in the contract, right?
Yes.
The person that drafted your contract only used the term domicile one time.
Not mine, but. Yeah.
Well, or I'm sorry, the AAA contract only used domicile one time.
Correct.
What they use the word reside multiple times, right? And so if we read it the way that you want us to read it, we have to say that reside and domicile are the same word. They're synonymous.
Yes.
So we're essentially negating that term domicile and we're replacing it with the word reside. Now, on the other hand, if we look at it and we say, okay, well, what the parties intended here, what the drafter intended is domicile means something different than resident. That would seem to be consistent with the contract. Otherwise, why wouldn't it say reside inside of domicile? And I think if we step back and we looked at the way homeowners policies work, that makes sense to me because the relative has to be domiciled there. The named insured only has to reside there to be covered. Why? Because named insureds often are, snowbirds. They've got a residence in Michigan, they got a residence in Florida. And the fact that maybe they're domiciled in Florida, but they live 5 months out of the year in Michigan. Well, so what? They're still covered under the contract. It says you need to reside, at this house. Well, I do. I have two residences. I have my Florida and my Michigan residence. I live in Michigan 5 months out of the year. But the insurance company says when they're drafting this document, if you want your relatives covered, they have to be domiciled there. It's not enough that they reside there. So I think, reading the whole contract, giving meaning to every word, I don't know how you get around that. How do you get around that?
Your Honor, it's a good point. Frankly, it's probably, in my opinion, the best argument that Member Select has. But again, we're looking at the situation where I'm just going through the steps that have been laid out is how do we interpret this? We give, if it's not a defined term, we give it its plain and ordinary meaning. And a plain and ordinary meaning of the term domicile does include residence. And if they wanted to make it clear that they meant domicile in the legal sense, they could have defined it that way in the policy and made that clear and not really up for debate.
Okay.
But instead, they employed a term that has a couple different meanings, one of which includes residence, and that's the way we submit that it should be interpreted.
Understood, counsel. Any other additional points you want to make besides
No,
really hanging your hat on the plain meaning, and they
Yes,
could have
that-
defined it differently if they wanted to?
That's right, Your Honor. Thank you.
Nothing else?
Nope.
Rebuttal.
Very briefly, I really don't have that much to add unless the panel has any more specific questions for me. Just in this case, we don't have to really depart from this plain and ordinary approach because I think the Google search kind of revealed it. Domicile is one of those terms that really we only use in the law. You don't talk to your friends about domiciles and saying, I'm going to relocate my domicile when you're saying I'm moving. It's a legal term. It has a precise legal term. And when a legal contract is using that precise legal term, I think everybody should assume, even an ordinary person, that it's going to be using the legal definition that Google gave, the legal definition that is in even Merriam-Webster. And that's what the contract in this case needs to use.
Any questions?
No, but it's a fascinating issue and you both did a great job briefing this, so we really appreciate it.
Thank you, Your Honors.
Thank you. That case is submitted. That completes our 10 o'clock session today. We're going to take a brief recess and come back and start the 11 o'clock. Good morning. Thank you for your patience. We will start with the 11 o'clock case call panel. Item number 22, case number 372-574, Christensen v. Armbrustmacher. Did I get that close? Okay, great. Thanks. As a guy, Trebilcock, I try to do my best.
Good morning. Steve Hicks, on behalf of the plaintiff appellant, Mark Christensen. This is a third-party motor vehicle negligence case. It's basically a motorcycle versus truck situation. If I could just say one thing about sort of set the scene. This is a rural two-lane highway. We're probably all familiar with those in Michigan. There are a lot of them. This is M21 over in Ionia. And defense makes a lot of the fact that that Christensen, my client, was passing at an intersection or passing as he approached an intersection. And, I think of myself as a fairly cautious but little impatient driver. So I really took a close look at that because I'm like, gee, can I not pass in that situation? Does the intersection somehow preclude me? And I couldn't find any statute that precludes you when you're in a passing zone and there are no cars at the intersection. And
When the car's turning right, you can kind of speed around them and
you
go on your way.
You can pass in a passing zone if it's permissible to do so. You just have to be clear that there's no one coming the other direction. So this repeated a statement about like he did so approaching an intersection or he did so at an intersection. I think it's kind of neither here nor there. They haven't cited any statutory violation for that. So I just wanted to say that.
The other issue is that the road markers or the road striping on the highway is striped for passing even where the intersection is. So
yeah,
that also would make it, if there was such a rule, it would certainly make it confusing for the motorists.
yeah. It continues now. Your ordinary sense of caution, you're going to look to see if there's intersecting vehicles, that sort of thing. There weren't any in this case. So I just want to kind of paint that scene.
Yeah.
As the court knows, the defendant's position in this case, and the position which with the trial court agreed, was that no reasonable juror could find that the plaintiff was not more than 50% at fault for this accident. Basically, that's in reliance on the fact that he failed to stop within the assured clear distance ahead, MCL 257.627. That's basically where the trial court ended up. That's what the defense argued in this case. And the
Aren't there
court-
some fact issues present regarding whether or not the turn signal A was used and then B, whether it was even functional? And the owners showed up after, during the crime scene and
Yeah.
reconnected it?
It's you're going exactly where I'm going, because I've got four factual points that I think the court should consider that I think go contrary to the trial court's ruling and the defendant's position in this case. And the first one is the one you've alluded to in part, which is that it's clear that no left turn signal was used here. At least there's not only the testimony of Christensen, the plaintiff, that he saw no turn signal. There's also an independent witness, a motorist coming the other direction that says he turned left. I never saw a turn signal. Now, curiously, the trial court deals with that in the opinion. If you take a close look at what the trial court's saying there, as best I can discern, because it's a little confusing, the trial court seemed to be saying not seeing a signal, meaning the motorist coming the other way, the independent witness, doesn't mean the signal wasn't used. Frankly, that's a bit baffling to me, because it's certainly evidence that of one of two things. He either didn't use it or it wasn't working. And not just on the rear end, this is her coming from the other direction. So you have both front and rear and front saying no turn signal used. So I don't know what the trial court was getting at there, but I think it's sort of indicative of the trial court's willingness to decide facts in this case. I'm going to get to the other point that you raised, Judge Chilcock, with regard to the lights. I'm going to do that third. The second point I wanted to make was that the defendant, acknowledged being unsure of where he was going in this case. He's approaching an intersection. He's not sure if he's passed the road that he needs to get to, and he's equally importantly using his cell phone for directions. Now, his claim is that I had the cell phone on, I had it in the cup holder, I was using the audio, and certainly that plays better for him. It still could be a distraction, but it plays better. And plaintiff doesn't have any evidence otherwise.
Right.
No one's sitting in the seat next to him. But that doesn't mean his credibility doesn't need to be assessed by the jury. The jury can listen to that and say, that's all very convenient. I don't buy it. And that is their function, and the court, with its ruling, is going to allow the jury to do that. Let me address the lights on the trunk, because this gets a little bit confusing. The plaintiff's pretty clear that you didn't see a turn signal working. Initially, he said, I didn't see any brake lights, but I'll acknowledge that could be because the truck is just slowing down, and he did acknowledge that the truck was slowing down. With regard to the lights on the vehicle, you're right, Judge Chilcock, that the lights, when they're on the video camera, the body cam footage, when the police officers are looking at and checking the lights on the forklift, the left side is not going off, the right side does go off. So there was a problem with them on the forklift. That problem goes away, and admittedly goes away, because an employee comes to the scene, Brad Renard, and he reattaches them. He goes and checks it, and he says, oh, well, it wasn't attached, and reattaches it. No one says anything to the state police, hey, I changed it, I fixed it, whatever. I don't know if they were asked or they had the opportunity. I don't want to cast
And
aspersions.
defense argument is, oh, that could have happened during the accident. It got knocked loose and we just reconnected it after the accident.
It's possible. I think the jury's got to make its own determination on that as well. But the other thing I'd say about the lights, with regard to one light flashing on the forklift and the other light doesn't work. It does both. There are both turn signals and brake lights on that forklift. They're basically, as the defense has argued throughout, they say they're redundant of what's on the truck itself. But here they're confusing, because if he does hit the brakes, he's going to put that right side light on, but no left side light on the forklift. So, and they're bigger lights. They're actually bigger than what's on the truck. So you might see a flash there when that happens. And that would be consistent with what the plaintiff said was, that he seemed to be turning right. He seemed to be slowing down to make a right.
Or if he's
turn.
tapping the brakes, it
Yeah.
mimics a turn signal.
Yeah, it gives him an impression of that. Let me talk about the lights a little bit specifically with regard to the Code of Federal Regulations. Defense argues that the lights are redundant. You have lights on the truck itself. And that's a fair point. You do have a turn signal light on the truck on each side, and you have 2 stop lamps, which is what is required. The problem for them is that the forklift the load is attached to the back of this truck. And if you look at the pictures, you can't see all of those lights. So you've got required stop lamps. You've got to have 2 of them that aren't showing up. And the trial court discussed this in their opinion. They say we didn't preserve this argument, but it's actually discussed in the trial court's opinion. So I think it's fair game on appeal. And so that's kind of a description of the light situation and what was going on with the lights.
If we decide that it's not preserved for appeal, do you still think you still get the relief you're seeking, which is going back to trial and effect issue?
Absolutely. I mean,
Okay.
I brought the other 2 points up first because I think they are the most salient points. The independent witness and the fact that there's evidence he didn't know where he was going and that he was on his phone.
Okay.
I mentioned the lights to get to my 4th point. I went through the description of lights to get to the 4th point because it gets to the issue of whether a pre-trip inspection was conducted or not. The Armbruster is pretty frank about these. Like, I don't recall specifically doing one. I don't recall checking the lights. And then there was some testimony that, oh, I usually do one. And then afterwards, according to the testimony from his boss, whose name I'm forgetting at the moment, they did institute some procedures in terms of doing the pre-trip inspection. So that did come about later. But if the pre-trip inspection had been done, if the Code of Federal Regulations had been followed, they would have found potentially the light not working and reattached it. And if it's loose, maybe taping it in there, duct taping it in there or something. They might also have discovered, our stop lamps really aren't showing very well. We should do a good job of making sure the forklift is giving the right signals, because we need to have that to be safe. And you don't need to have a violation of the federal regulations. You still have a common law duty to use ordinary care that's going to apply more broadly. And I would say doing that inspection, checking the lights, making sure they work all falls within that. So bottom line, our position is that when you take these factors into account and the jury's weighing of those factors, a reasonable jury could find that the defendant was either more at fault or perhaps equally at fault, in which case they'd split. Tie goes to the plaintiff, I guess. So that's our position, is that these factors change it. It can't just be analyzed as a failure to stop within the assured distance case.
Understood, counsel. Any questions?
Nope.
Thank you.
All right, thank you. You have time for rebuttal if needed.
Good morning, Your Honors, and may it please the court. My name is Simone Papadia, and I represent the defendant appellees Armbruster as well as Weaver Lumber. So I'd like to discuss this morning regarding, there's been a lot of talk about whether or not the lights were on, lights were not working, turn signal, things like that. I would like to direct the court to the post-accident interview with Mr. Christensen, as well as Mr. Christensen's interrogatory responses. So in Mr. Christensen's post-accident interview, he acknowledges that the truck was slowing down in front of him, and he says that the brake lights weren't working, which, as in the brake lights weren't on, they weren't there. And then in his interrogatory response, he says that he didn't see any turn signal. So our position is that Mr. Christensen, no reasonable jury could find that Mr. Christensen was reasonable jury would be able to find that Mr. excuse me, that no reasonable, that there's essentially not a question of fact regarding fault, that Mr. Christensen was more than 50% at fault for the accident, because he, in his own words, recognizes that that the truck in front of him was slowing down and that he didn't see, there was no indication as to which way the truck was going to turn. And for whatever reason, he assumes that the truck is going to turn right and tries to pass the car on the left. And
That first statement you referenced, is that the police report?
That's it's Mr. Christensen's video interview post accident. It's in the ambulance. And then which is, I believe, part of the record in the case. I believe the court would have access.
But there was also a police report. I didn't know.
There was also a police report. That is correct. And then Mr. Christensen's own interrogatories, which essentially talk about the fact that he didn't see a turn signal at all.
That's the second statement.
That's
I
the
was just
second
wondering
statement.
which of the first statements you were talking about, but go ahead. I'm
Sure,
sorry.
that's correct. So those are the I think that the arguments that so those are the points that I wanted to highlight to the court, is that Mr. Christensen essentially made an assumption as to which way the truck was going to turn. And under MCL 257.627, he has to be able to drive his car in a way where he can stop within a short, clear distance of the car. The other point that counsel makes is regarding whether or not Mr. Armbruster was distracted. In Mr. Armbruster's post-accident interview, which is also videotaped, the police officer asks him, were you on your phone or anything? And he says no, and then he says, my phone was on the seat next to me. So any sort of extrapolation that was distraction is speculation, and it's not. It doesn't lead to causation. It doesn't lead to. It's not admissible. He says no, and then he says that it was on the phone. It was on the seat next to him. So those are the points that I would like to point out to the court.
But isn't that I guess where I struggle is you say that with plaintiff, essentially, because he apparently didn't slow down or didn't stay behind, then it's clearly his fault. It's not a question at all. But when there's these other questions that are presented and that are undisputed, that at the time after the accident, the linker wasn't attached and wasn't working. There's an issue whether or not that happened apart from the accident or not. He's admittedly using his phone and confused the driver of the truck, admittedly confused and not sure where to go, and has the phone, as he admits, on his seat. There's an issue about whether he was, at his best case scenario, he's got it on and it's on his seat. Isn't that enough to say, look, you may be right. His client should have slowed down, shouldn't have tried to pass if he wasn't sure, should have stayed back. That's the safe, reasonable thing to do. But isn't that enough with all that other stuff that's for a jury to decide as opposed to the court?
So the position of the defense essentially that Mr. Christensen recognized that he didn't see any lights, he didn't see any indication on the truck at all as to which way it was going to turn. Mr. Christensen makes an assumption as to that the truck was going to turn right, and the truck ended up turning left as Mr. Christensen was trying to pass him. And I think that is where the trial court found, and that's ultimately in the trial court opinion, the last page where the trial court finds that he didn't stop within a short, clear distance, even though he recognized he had no reason to. He made an assumption as to which way the truck was going to turn, and that is enough for summary disposition in the defendant's favor.
Isn't it a question whether or not that assumption was reasonable under the circumstances? Is that a question for the jury?
I would argue that no reasonable jury would be able to find that is not that there is no that there's a question of fact on that point. This is that he makes an assumption as the truck is going through an intersection. And regarding passing, one of the arguments that regarding passing on when to pass is that under MCL 257.638, the car that's passing has to also take account for cars that are coming from the opposite direction, as well as the vehicle that's being overtaken. So when he's not sure as to where that vehicle is going, he's making an assumption as to where that vehicle is going, and he's attempting to pass it. When when he himself recognizes that the car is slowing down, that is objectively unreasonable for Mr. Christensen to have taken that action.
What about passing or attempting to pass at an intersection? Have you found any law that indicates that that's not allowed, whether it be statute or case law or ordinance?
I have not found a specific law that pertaining to passing on the intersection. But I believe that the fact that it was at an intersection and taken into account just the statutory, the under MCL 257.638, that has to take into account the overall factors. The fact that that the passing was happening at an intersection is relevant to the reasonableness of Mr. Christensen's actions. He made an assumption that the car was going to turn right without really having any reason to do so, and then he tried to pass, and then this accident unfortunately happened.
What about changing lanes? Isn't there a portion of the Michigan Vehicle Code that says you can't change lanes at an intersection? Isn't passing essentially the same thing if you were going to have to get into the other lane to pass?
I'm not aware of specifically that off the top of my head, that particular statute regarding passing, but I would agree that changing lanes is akin to passing. And again, that supports the fact that it is objectively unreasonable for Mr. Christensen to have decided, try to assume where the car was going to turn. Aside from that, I rest on the arguments in my brief, unless the court has any further questions.
Any other questions?
Thank you.
Thank you, counsel. We appreciate your responses. Rebuttal?
Just a couple of points on rebuttal. First of all, I'd say that passing, while it involves a change of lane, is not the same thing as changing lanes. To the extent that, and there is a provision in the Motor Vehicle Code about changing lanes. It's very specific to lane changes and when they're made on different types of roads, as I recall it. And it doesn't talk about intersections in my recollection. So I would say they aren't the same thing. With regard to the inconsistencies of my client's, the statement that he made to the police and then what is said in interrogatories, I don't really think they're inconsistent. And I'd note that, what counsel doesn't mention is that there was also another independent witness, a witness who was traveling behind Mr. Christensen, who talked to the police afterwards. And the thing she said that was most germane, her name's Sarah Broderick. The thing she said that was most germane, because granted, she didn't see the accident close up. She was not able to comment on signals, that sort of thing. But it says, Sarah stated the motorcyclist shouted the lumber truck did not have its turn signal on. So it's right there in the police report. She's saying that my client, Christensen, was saying at the scene, having been knocked down, didn't have his turn signal on. So it's there. The interrogatories focus on the turn signal. The statement when he talks to the police, he's talking a little bit about the brake lights as well. This is an individual who's traveling roughly the speed limit and has to either dump the bike or eat the truck in front of him. So I don't know how much we can focus on inconsistencies in his testimony when you have to make that sort of split judgment. The credibility point, I just want to hit one more time, because certainly Armbruster says, I wasn't using the phone, and I think it is correct that even if you're not looking at the phone, you're engaged in getting those directions, you're listening to the auto, you're confused about where you're going. I think that's enough. But if that isn't enough for the court, I think the Supreme Court case of White versus Taylor Distributing is very instructive. 42 Mich 136. In that case, it was the defendant who was claiming a sudden emergency because he caused the accident, rear-ended somebody. He was claiming that, I was having some stomach issues and it was an emergency. And the issue that went to the Supreme Court in that case was, well, gee, plaintiff, you didn't have any countervailing evidence you didn't have any evidence that he wasn't having this problem that he said he was having. And because the Court of Appeals had said, well, you didn't have, and the trial court also said, you don't have any countervailing evidence. Sorry, plaintiff, you got to come forward with something. Supreme Court reversed that, and they said, no, because the jury has to assess the credibility. They can choose not to believe this story that the defendant is telling in that case about gastrointestinal issues causing him to have, I think he said that he had a syncopal episode because of it, and then caused the crash. I mean, they can choose to believe that or not believe it, but it's one of those fact questions that has to be resolved by a jury. So with that, I'd ask that the court reverse, because I think a jury could find that the defendant was more at fault.
Thank you, Counsel.
Thank you.
Any questions? No. All right, that case is submitted.
And when I said earlier that the last case was fascinating, I'm pretty sure the two of you are the only people in the galley that agreed with me.
Calling item number 23, case number 373103, Sarah Carlin v. Mark Drasnin. Counsel, please approach and put your appearances on the record.
Thank you, Your Honors. May it please the court, my name is John Turk. I'm here on behalf of the appellant, Sarah Carlin. I am domiciled in Saline. Judges, it's obvious to me that you have read everything, and so I would like to laser in on what I think is the key issue raised on appeal, which is whether the successor attorney, Ms. Johnson, had time to fix the problems that my client says were caused by the defendants in this case. The discovery cutoff had closed before successor counsel got involved, and the defense argues, well, there is the Domestic Relations Arbitration Act. The arbitrator could have engaged in discovery, and while I agree that's true, the arbitration agreement did not open discovery again. And I think some evidence of the fact that it didn't is the fact that the first arbitration hearing was in August of 2022, and the order appointing the arbitrator and submitting it to arbitration was entered on June 14 of 2022, 2 months before. And so what I would say in response to defense arguments is that an arbitrator's permissive power to order discovery or to request information or to compel parties to produce information is different from the full-throated discovery that all litigants ought to have, that Ms. Carlin should have had the right to engage in, and she did have the right to engage in during the divorce proceedings, but because of what we say were the defendant's failings, did not engage in. It has striking parallels to this case, which was filed as a C-10 motion right out of the gate without giving her in the legal malpractice case an opportunity to show and demonstrate to the court, this is what that discovery, had it been done in the divorce case, would have produced. And that's why fundamentally, I think the trial court erred. There are other issues too, not just the failure to conduct discovery. What happened to the $300,000 that the husband took out secretly when he represented himself to the lender as a single man, when in point of fact he wasn't? What happened to the $100,000 in a Fidelity IRA that Sarah recognized at some point he had withdrawn, but then distributed to different accounts? Why did the defendants here stipulate to limit discovery to post-2015 accounts when the parties were married in 2011? Ms. Carlin had no input in any of those issues. She had asked them to secure documents showing the money transfers. Money leaves a trail, of course, and none of it happened. And so to say that Ms. Johnson had the time in 2 months when she was at the mercy of the arbitrator's decision to allow or not allow discovery is simply not the same as the 11 months of discovery that these defendants had and essentially sat on their hands during.
I recognize, judges, that I might end up losing this case if I'm permitted to litigate it to its completion. I'm capable of losing every file in my office, and this is not any different. What I'd like to do is have a fair fight. And when my client and I have our hands, not literally, tied behind our backs, and we're expected to defend ourselves and say on a C-10 motion, where I have an obligation affirmatively to come forward with evidence right out of the gate, no initial disclosures, no oral discovery, no written discovery. I can't issue subpoenas because those initial disclosures haven't been done. And I'm told by the trial court and by these defendants, you don't have the evidence to prove your case. That's fundamentally where I think the trial court got it wrong from a 30,000-foot perspective. If I lose the fight after a fair fight, I can deal with that, and my client will have to deal with that. But I'd like to have the fair fight. And I don't mean to use the violent imagery in that literal way, but in a sense, it is, because of course we are in an adversarial system. I simply like to be able to sit down and ask these people questions and get documents and see where that takes us. If at the end of the fact, at that process, Judge Grant says to me, Mr. Turk, I don't think you've created a genuine issue of material fact. Fair enough. I may have other disagreements with that, but I don't get to do that. Now, with that said, I presented not only my affidavit pursuant to 2.116, trying to lay out the discovery I think might matter for this resolution of this motion, but also the affidavit of Sarah Carlin attaches Exhibit 3 to my appendix. And I won't go through it and cite it chapter and verse, but in it, she lays out a number of these issues I alluded to briefly. The $300,000 line of credit as a single man, the $100,000, the failure to enforce the status quo order because her ex-husband tried to trick her into thinking he had deposited his entire paycheck when he'd only deposited 6,000 some odd dollars instead of the full 11,000. Well, over the course of a contested divorce matter, that matters to a woman who's not otherwise making significant money and can afford to pay her a lawyer and can afford to pay kids' tuition and pay for the necessities of raising children and running a household. The trial court sloughed that off and dismissed it as quote unquote speculation. I don't think there's anything speculative in there. I mean, I acknowledge that in some places, Ms. Carlin said I had suspicions about what my husband was doing with these funds, but that wasn't based on nothing. That wasn't based on wild conspiracy theories. These were based on evidence she had and information she had. I know, she says, I found out that $270 some odd thousand was wired purportedly for a down payment on a home, but that wire happened before the house was even listed on the market. And she said, I went to my lawyers, I asked them about that to do the digging to find out what was there, and it wasn't done. And so that's what I have to say. Thank you.
Any questions?
Thank you for your
Thank you,
time.
counsel. You have time for rebuttal.
I appreciate it.
Good morning, Your Honors, and may it please the court. My name is Simone Kapadia, and I represent the Draston defendants appellees. I'd like to reserve about 10 minutes of time for co-counsel for the Ribbit defendants to speak.
Got it.
Thereafter. So this morning, I'd like to, this court should affirm the trial court's grant of summary disposition in the Draston defendant's favor for essentially 3 reasons. So the crux of Ms. Carlin's claims in her legal malpractice claims are essentially that there wasn't sufficient discovery done regarding her ex-husband, Stuart Carlin's assets, and that Mr. Carlin has, that Mr. Draston has charged excessive fees. And the court should affirm summary disposition for the 3 reasons that the record establishes that in the underlying case, the Draston defendants undertook significant discovery efforts. Pages 6 to 7 of my appellee brief discusses the extensive discovery efforts that were taken, including sending interrogatories, supplemental interrogatories, second supplemental interrogatories, as well as filing a motion to compel, getting an order to motion to compel, and then filing a motion for sanctions alleging that Mr. Carlin did not comply with that order to compel. And then Mr. Draston also took efforts, which is in the record, which is established in the record, took efforts to obtain a status quo order as well as enforce the status quo order. And again, those are detailed more specifically in my brief. So the initial allegation that discovery was insufficient by the Draston defendants, I think the record establishes that that is incorrect. But even if there were discovery deficiencies under Boyle versus Odette and Melody Farms, successor counsel had the opportunity to cure any sort of alleged discovery deficiencies during the arbitration process. The arbitration was over 2 days. It was in August of 2022 as well as in November of 2022. Successor counsel, according to plaintiff's complaint, successor counsel became engaged in April of 2022. She filed her appearance in May of 2022. And both parties, importantly, both parties stipulated, Ms. Stuart Carlin as well as Sarah Collins stipulated to go to arbitration. So it wasn't like this sort of, I think plaintiffs insinuate that Ms. Carlin was forced to go to arbitration. Both parties in the underlying case determined, they stipulated that arbitration was the appropriate way to rectify the underlying divorce in that case. And during the arbitration proceedings, which again took place over 2 days, Mr. Carlin testified, Ms. Carlin testified, as well as they both had an expert witness testifying to the machine web business. And there was also the arbitration agreement. The arbitration agreement talks about the fact that the arbitration was going to encompass essentially all the underlying issues in the divorce, including the split of marital property, child support, spousal support, etc. So really any sort of discovery deficiencies that may have occurred could have been cured during arbitration. And during arbitration, one of the requirements, I know that my brief talks about specific provisions within the Arbitration Act, but the power that I would like to, the statutes that I would like to draw the court's attention to are MCL 600.5074, which is where the arbitrator can issue subpoenas, can issue an order regarding discovery relative to the issues being arbitrated, and MCL 600.5074, which is that the arbitrator has the power to order sworn statements regarding the parties' places of employment, sources of income, assets, and liabilities, as well as MCL 600.5076, which is that the arbitrator shall order parties to produce information that is applicable and material to an issue that is within the scope of the arbitration. So the issue regarding the allegations that the discovery wasn't sufficient in the underlying case regarding Mr. Carlin's assets and Mr. Carlin's financial position could have been rectified during the extensive arbitration process that the parties undertook.
Did your clients take any efforts to follow through on these discoveries? So that, counsel suggests that there's essentially, requests went out, but there was no responses. There's nothing for him to work with. There's nothing for him to fight with, to use his words. What's your response to that?
The record establishes that the Draston defendants did file motions to compel. They received an order to compel discovery, and then thereafter arguing that Mr. Carlin was not abiding by the order to compel, filed a motion for sanctions for not abiding to compel. So I think that there was, I think the record establishes that there was extensive discovery taken in the underlying case. But regardless of that, setting that aside, successor counsel could have rectified any sort of alleged discovery deficiencies. And the last point that I would like to make is just that Ms. Carlin's excessive fee issues are not properly before this court within because it is an alleged ethical violation, which under MRPC 1.0B does not give rise to a civil cause of action. I would also point this court, as I did in my brief, to the Olson versus Olson, which is a published case, and then the unpublished case of Rhodes, which discusses that even this issue with the value-added provision in a high-end divorce is not actually improper. So unless this court has any further questions, I would.
Why didn't you just wait until defendant's depositions and then file the suit?
I think it's a matter of the fact of depositions are, there's no reason to go forward with a case that is on its allegations. Without that summary disposition is required on a case that out of the gate what's the point of going through depositions when Ms. Carlin's claims already fail on their merits? I think that is the,
Then why not file it?
well, a C8, well, because of the fact that a C10 motion does require, on a C8 motion, it would be limited to the pleadings alone, and it is relevant for the court to consider the filings in the underlying case, which is why it was filed under a C10 as well. But with an understanding of the record in the underlying case and the fact that there was an extensive arbitration proceeding, that they would not be able to establish causation. So the record shows, so it's the matter of filing a C10 now versus a C10 later. It's a matter of why allow this case to continue when it's already, summary disposition is appropriate already at this stage.
Thank you. Counsel, I believe you wanted to make some argument.
Just to address your honor's point, you asked, well, I was part of the underlying, the circuit court, and there was a conversation that we had with Mr. Anderson, that I had with Mr. Anderson, and the thought was, this is a C8, C10 motion. Some of it is C8 because, for example, the excessive fees, we don't need any proof for that. That's a question of whether that could be a lawful activity or not, or unlawful, or a cause of action. The rest of it was, we think we have a really, really good chance at the proximate cause issue. And we did.
Was your client served with a deposition notice?
No. And just one point of correction. Mr. Turk or whoever was representing the plaintiff at any time could have issued initial disclosures. He didn't have to wait for an answer. Initial disclosure said they can be filed at any time. He could have served his initial disclosures the day with the answer, or when we filed the motion. None of that happened. And I don't have the briefing schedule, I'm sure, from the underlying case. It's listed online for the schedule, but there was a fair amount of time between when the time the motion was filed and when the first response brief had to be filed. My guess is it was probably, knowing Judge Grant, it was probably had 35 days to file a response brief. We never received initial disclosures. We didn't receive discovery requests. We didn't receive anything. All that could have been done. I'm not blaming Mr. Turk for it. I think he's a pretty smart guy. I've had cases with him before. I think he understood the argument. But what if you, did I bring it up here? Oh, I did bring my pad of paper up here. I just was writing some notes, and I think Your Honor asked counsel about the issue about discovery, how much discovery was what we did to follow up and all that. There's a significant amount. And again, we had gone through it and counsel was absolutely correct. And Judge Grant listed all the discovery that was sent in her opinion. And we've got it in our briefs, both counsel and I. There was a significant amount of discovery requested. And not only that, but there was motions to compel, and including the last one that was filed with Judge Gant, is she reserved the right toward fees and sanctions to, Ms. Carlin on the discovery abuses. And that was towards April. And that was, about the time everybody started moving out of the case. I would like to point out, Your Honors, is that the receivership order, the stipulated order for appointment of receiver, grants extraordinarily broad powers, which you would expect in a divorce case, given the parties involved. And that was April 28th, 2002. And you can go through the ability of the receivers to issue subpoenas, to issue to third parties, to ask for discovery, all those things. And they're too lengthy to provide a written list. We provide some of it, but that order was also signed by Sarah Carlin for approval. She stipulated to that, and she's got her signature on page 14 of the order, stipulating the order. Do I expect her to be a lawyer? No, but she obviously had read it. So I guess I would like to focus on what I would call the supposition. And I was struck by reading the affidavit of Miss Carlin when we first got it at the trial court level, and I was struck with the complaint and it reminded of Carl Sagan quote, where he says, "The absence of evidence is not evidence of absence." He's arguing, Carl Sagan is just, well, maybe there's a scintilla of life out there someplace, or maybe there's a scintilla of evidence, but that's not the standard for your honor. If you read, for your honors, or at the trial court level, if you read through Miss Carlin's affidavit, she does more than, and that's exhibit 3 of plaintiff's brief. She uses the phrases, "I suspect," my belief, my suspicion. She uses that about 7 times in identifying all these little allegations.
We understand.
Yeah. So I guess that would be my point. There was nothing factual for any party to rely on to deny the motions.
Thank you,
Your
counsel. Rebuttal?
Well, before you start, let's have you answer the question he posed, which is, why didn't you serve initial disclosures and serve dep notices for these 2 defendants?
I requested for Mr. Anderson, I believe, his client's representation file, either before we filed suit or shortly thereafter. I did not file initial disclosures because I have interpreted the court rule to mean that I have to wait until I get an answer, and then I have to submit those initial disclosures in 14 days. So if I'm in error on that, then I am.
I don't agree with you on that one, but I understand why you would say that.
That's what I did and why I didn't. And I also don't believe in bums rush discovery. I'm not going to unilaterally notice a deposition. I have other cases going on, and although 35 days is 35 days, this was in Mr. Drasnin's words in his fee agreement, a complex case, as I think he used the term. I can't get my arms around all of that factual material, even if I ask for it, within the 35 days that Judge Grant requires me to draft and file a written response brief. I did what I could based on the information I have, but I would note that, as Ms. Johnson noted when she got in the case, she had not been provided the defendant's files. I still have not been provided the defendant's files. I think Ms. Johnson never received the defendant's files because my client never received them. And I am certain that if Ms. Johnson had them, my client would have requested them from Ms. Johnson. I'm sure Ms. Johnson would have provided them. So to this day, I don't have the defendant's files. And I think that's a fundamental failing. I'm sorry.
Is there anything in the record that Ms. Johnson requested discovery and was denied that request by the arbitrator?
It's silent. There's not anything saying she did and was denied, nor is there any evidence that she asked. I just don't know. I don't have her file either. And I did have a conversation with her, I believe shortly after the motion was filed. I was not provided by her a copy of her file. We play the game for a reason. When Appalachian State came to play Michigan many years ago, they played the game not because, and I'm sorry to already see one shaking of the head.
I don't know why, want to bring that
I
up.
could have picked a better.
I think it's a great, let's talk about it.
I could have picked a
Let's
better
bring it out.
example, but, and I appreciate the smiles, Judge.
3-time national champion Appalachian State football team.
Yes, that one. We do discovery for a reason, and you give litigants a fair shot, especially on a C-10 motion, and this was not it. And to stand here and say, well, why bother with a C-10 motion because we're going to win, seems to me to be assuming the fact, not in evidence, assuming the conclusion to be concluded. Again, whether an arbitrator has the authority to do things does not mean that he or she will. Doing those things is the purview of an attorney when he or she is representing a client in any kind of civil litigation, and that didn't happen here. There are lots of requests for production of documents listed. I don't see a single subpoena to a bank. I don't see a subpoena to a financial institution showing the money trail, what happened to the line of credit, how that was spent down, where the IRA fidelity went. I see none of that. And I can see that requests to produce were submitted. I can see that apparently the judge ordered that they be produced, and I see apparently that Mr. Stewart did not produce them. But that has nothing to do with Fidelity or any of the other financial institutions that had any of my client's money or her and her now ex-husband's money. On the excessive fee issue, I only want to say one thing, which is that Beatty versus Fernschchild, I'm not alleging that a violation of rule of professional conduct gives rise to a cause of action, creates a cause of action where none otherwise exists. But under Beatty versus Fernschchild, published Michigan Court of Appeals case, evidence of an ethical violation constitutes a rebuttable presumption of malpractice. Now, I will concede there is law going both ways on that point, but it's not quite as cut and dried as sister counsel would make it seem. And then the last point I want to reach, and I appreciate your indulgences. I think it's interesting that when Ms. Johnson was having the conversations with Ms. Carlin, as Ms. Johnson was getting into the case, she sent on April 25, 2022, an email, which I have attached as Exhibit 7 as part of my brief. And she says, and I'm only going to quote a very short portion of it. These deadlines, referring to the scheduling order deadlines that had passed, place you and me in a very precarious position if trial becomes necessary. Are you aware of that? I need you to understand that because discovery is closed, I cannot send subpoenas, request documents, conduct depositions, or anything of that nature. I am precluded from doing anything to gather more information. Do you understand that? Now, Ms. Johnson is doing exactly what she should. She's being blunt and candid and clear with Ms. Carlin about the handcuffs that have been placed on her. That's one of the compelling reasons Ms. Carlin felt she had no practical obligation, or practical reason not to go to arbitration. If you'll note, the arbitration agreement was signed the first day of trial, June 14, 2022, at least according to the scheduling order. Ms. Carlin will testify if she's given the opportunity that she felt she had no choice but to agree to arbitration because she had nothing. And Ms. Johnson didn't even have the predecessor counsel's file at that point. And so if by kicking the can down the road, they might do a little bit better, fine, let's do that. But otherwise, I've got nothing and I'm going to get hammered in the divorce court trial. That's at least what she will testify to. Unless you have questions, I have nothing further.
She was told they are in the process of appointing a discovery.
Pardon me, I'm sorry.
She was told they were in the process of appointing a discovery master at that point.
Yes, I think that's right. Yes. Thank you.
All right. Thank you, counsel. Appreciate your time and your arguments. That case is submitted. Calling item 24, case number 372419, Crystal Farmer v. Syed Ahmed.
Good morning, Your Honors. May it please this honorable court, Jan Rubenstein, on behalf of Crystal Farmer. Your Honors, I'm going to try to keep my comments brief. I'm sure that the panel has read the briefs carefully, and I think that the issues were thoroughly and somewhat exhaustively addressed. Now, I would like to reserve a few moments for rebuttal, but I think this is essentially a straightforward issue, and actually I think that my opposition and I don't necessarily disagree on all that many terms. In fact, in reviewing their brief last night, they take the position that this was a voluntary dismissal pursuant to MCR 2.504. I tend to agree. I think that the language used at the trial court level was straightforward, although the legal analysis a little bit less so. The legal analysis, actually, I find very interesting, and dare I say this would be possibly a good bar exam question, because the language seems straightforward. The language seems like the plain meaning, but what is the actual effect of the language that the trial court used? Now, incessantly throughout everything I've read and everything that's been argued throughout the briefing, the motions, responses, every court hearing, there's been a lot of communication regarding discovery and delays, extensions, things like that. To some degree, I think that's a little bit of a red herring because there's nothing on this record that shows that there was anything due at the date of the final pretrial where this case was dismissed, July 23rd, 2024. There was nothing pending at that point except for my client's two attorneys' motions to withdraw. So there had been no finding that she'd ever violated an order. And at that point in time, yes, I mean, we'll acknowledge just for the context of this case that There was an 8-month stay put on this case due to my client's health issues. And there was multiple discovery challenges and issues and motions. And in each one of those, opposition had asked for extensions and they were granted essentially. Part of the complication in that was that my client was traveling from out of state to Tennessee to Michigan for depositions. And I believe there was 4 independent medical examinations. So scheduling was a little bit of a challenge.
And there were fights and objections to whether or not who had to appear where and
Had to appear, how many IMEs, should it be by Zoom?
Yeah.
Yeah, all
all
of
the
this,
fun fights.
which we've all done. We've all been there. But ultimately, at the day this case went to court, there was over a month before trial. There was no remaining discovery issues that I've seen. There was no claims that there were any violations of any orders. So there was no basis, no motion pending, nor no basis to take punitive action at that point in time. Now, I'm going to go over a couple of sentences from the hearing because I think they're really pertinent. And they give us a little bit of an insight as to how this transpired. Just to cut to the chase here, it is my position that 2.504 B2 controls, that this is a voluntary dismissal, but it should have been without prejudice, not with prejudice. Very simply because there had been no finding that there was any prejudice or inexcusability that would justify a with prejudice dismissal. And there was also no statement made on the record by Judge McCarthy indicating that I am going to dismiss this with prejudice. That was simply inserted into an order, and the order did get signed, which is obviously why we're here.
If we agree with you that it should have been without dismissal, does that mean you go back to square one, or do you go back to the point where it was dismissed? So discovery is done and all you guys have to do is pick a trial date and go.
Well, I would submit to you that at that point in time, if my position is correct, and it should have been a dismissal without prejudice, then I think we go back to square one. I do think, and I don't know if that's the right answer, but that is my honest opinion, that you would have to go back and my client, if she wanted to pursue it and was within statute, would have to refile the case. That's what I believe would have happened, should have happened, I guess, in this dismissal. Now, I don't believe the dismissal was necessary under any circumstance. Now, clearly, there was a debate between the court and the 2 lawyers, well, 3 lawyers, and my client on the record. That debate, it did venture into the world of argument. Okay, they got into an argument on the record. Clearly, there was unhappy people in that courtroom that day. My client probably the most so. But that being said, during the course of this argument, the court basically indicated and gave my client the option. The court said, I'm not moving the trial and I'm not allowing these 2 attorneys to withdraw. So basically, Ms. Farmer, your option is to use one of these 2 lawyers or to proceed and come pick a jury yourself on the trial date. Now, the court never specifically said, well, you're precluded from hiring another lawyer, and that would have been, I also think, an inaccurate statement had she said that, but that was the impression that was communicated to Ms. Farmer, that she's now stuck. Now, she had over a month before trial. It is feasible that a lawyer could have come aboard, could have reviewed everything, and could have been ready for trial on time. The court had no obligation, nor was there any motion asking for any adjourned dates at this point in time. Simply 2 motions to withdraw. One of those lawyers specifically was discharged by my client, which, as you can see from our brief, I believe that requires a mandatory withdrawal of counsel. The other attorney, the issue really wasn't any type of breakdown, but there was an issue as far as the written representation agreement. It granted a limited power of attorney. My client wasn't comfortable with that. I don't know how that got resolved by Judge McCarthy's order, but that was the issue at that time. So ultimately, the court could have granted one or both of these motions to withdraw and still kept the trial date. There was nothing, and there would be no appealable issue, in my opinion, had that been the result.
Is that within the trial court's discretion?
Yes, of course, it's within, and the trial court has 100% ample opportunity to control its docket, which it should. I mean, we've all as.
But why is that not unreasonable?
Well, it would have been reasonable, but the court didn't do that. Okay, the court did not grant the motions to withdraw, deny. Well, I mean, the denial of the motion to withdraw is a lesser issue, in my opinion, than obviously the dismissal, because my client could have made do at that point in time. There were options. And specifically as to the Russell case that's cited by both the appellee and the appellant, that case, I think, is really important and telling as to this case. Now, appellee will argue that that case is analogous, and this court should take the same approach. But the reason I think it's important to distinguish is that case was, the motion in that case was to adjourn the trial. They were within the same week of trial in that particular case. And in that particular case, in that motion hearing, the attorney for plaintiff argued that he was not ready for trial. They simply didn't have the evidence to go forward. That was a far cry different than what Ms. Farmer had going on in this case. And in that case, that dismissal with prejudice made sense. And it made sense because if a plaintiff doesn't have the evidence to go forward, that is part and parcel to an adjudication on the merits. Plaintiff is saying, I can't win this case. Essentially, the case is over before it starts. But that's not what we have here. In this particular case, my client indicated, well, then you can dismiss the case because I told you I'm not going to go there. You have no right to bring me there. And the court says, all right, ma'am, I'm dismissing your case based on your request. And I think based on your request are operative words. The court said something similar in the order denying the motion for reconsideration. Essentially, that based on her request, the court had dismissed the case. So I think that that's where the voluntariness, I think there's no other reasonable interpretation than this was a voluntary dismissal. So then we have to get to, well, why should it or would it have been a dismissal with versus without prejudice? And the court rule contemplates that it's generally without prejudice, unless something different is articulated. And in this case, now my opponent will indicate that it was articulated in the order, but there was no analysis whatsoever on the record of any basis to dismiss with prejudice, of any prejudice to the defendant. In fact, the law requires that, and nobody addressed it.
I think we understand. Yeah, I think we understand that point. You
Sure.
raised that at the beginning.
So at this point in time, I think that the refusal to allow the attorneys to withdraw was, in my opinion, abuse of discretion. But the most egregious issue is taking away my client's stay in court. She was entitled to that. She had been a part of this case and pursued it for over 3.5 years. Yes, there were certainly words exchanged between her and the judge. I'm sure neither was happy with one another. That happens in litigation. But she was deprived of her day in court without any basis. And the only reason that the discovery and extension issues, I think, have been addressed to such a great degree is that there's an implication, although it's not expressed, but there's an implication that this is somehow punitive, that the with prejudice makes sense because of the history of this case, because she challenged some IMEs, because she wanted to do her deposition by Zoom, because of certain delays. And by the way, the trial court was wrong in several instances in that transcript where it said to Ms. Farmer, we granted your request to adjourn multiple times. Now, again, her only request was a stay that was granted, I believe stipulated to because of a health issue, but she had never beyond that requested an adjournment or extension of scheduling order each time and every time that was requested by the defendant. So short of that, if the court has any questions, I'm happy to answer.
No
Thank you.
questions. Thank you, counsel. You have
Thank
some
you.
time for rebuttal.
Thank you.
Counsel, state your appearance for the record, please.
Susan McKeever on behalf of defendant, Mr. Ahmed, and I have with me Mr. MCOA, who's trial counsel. Good afternoon, Your Honors. So it's interesting that counsel says that there's really only one issue here because in fact, that's the way we've always characterized this, which is that this was a voluntary dismissal by the plaintiff, and it was appropriately done with prejudice because she was refusing to come to trial and refusing to accept the trial court's rulings. The reason we went through, I think both sides went through the discovery history, and the reason for that was in the briefing, this was characterized as a discovery sanction to try to get this case under the Vincencio Dean cases, but it absolutely was not. And that's what the judge said when she was denying the motion for reconsideration.
Did the trial court make it clear that the dismissal would be with prejudice? Did she, if we're going to look at it under the lens of it being a voluntary dismissal, was that made clear to Ms. Carlin?
You mean it was made clear in the order, yes, Your Honor. The order says
at the
with
hearing,
prejudice.
though, was it?
No, it was not. but I don't know that that's required. I think that the requirement is that,
Well, the order was sent to the judge signed it, and there was a motion for reconsideration on that order, right?
right, and the trial court denied it because it would not have been appropriate to dismiss the case without prejudice under the rule and under case laws, particularly the Rosslett case, where there's several cases which holds that it's that a plaintiff cannot voluntarily dismiss if that would be prejudicial to the defendant. And in this case, the defendant did everything that he could do to get this case to trial. Yes, there were several continuances, but that was only because
Beyond delay and the inherent cost, what is prejudice?
you mean the prejudice with allowing this to be voluntarily dismissed without prejudice?
Correct.
Well, that would be tremendous prejudice. I mean, if this court were to do anything, it would, in my opinion, remand, because the defendant was not given the opportunity to argue that it should be with prejudice. I mean, that would have to be.
If it was remanded and it's a voluntary dismissal, and she's like, well, if this is going to be with prejudice, I don't want to voluntarily dismiss anymore. Wouldn't that be another permutation?
I'm sorry, can you repeat that, Your
I
Honor?
said, if it was a remand and this is a voluntary dismissal, wouldn't another option be that she's like, well, if this is going to be a dismissal with prejudice, then I don't want to voluntarily dismiss. Wouldn't that be another option that she would pick? Or could
Meaning the
pick?
plaintiff.
Yeah, sorry.
You mean in continue? So I guess the biggest problem with that is that essentially what the plaintiff was doing by saying that she would not come to court is that she was refusing to allow the court to enforce her scheduling orders. I don't think that there's any question that the court correctly denied the motions to withdraw.
I think that flips it again, right? Because a few moments ago, we were talking about the fact that this wasn't a discovery sanction. It was a dismissal, a voluntary dismissal.
Yes.
But then if what the tenets that you're bringing up right now all pertain to discovery sanctions or the court's inherent ability to have control over her own courtroom, which I understand she does have that power, but that's not, I believe what you were telling me a few moments ago is that's not what we have here. We have a voluntary dismissal.
We have a voluntary dismissal because the plaintiff was refusing to abide by the trial court's orders. The trial court refused appropriately to grant the adjournment. Now, brother counsel said that there was no motion for the adjournment. That's actually not true. There was Miss Farmer in her response to her counsel asked for an adjournment, and Mr. Davis also asked for an adjournment.
I've been through the record and I can only find one time when plaintiff asked for adjournment, which was when the 8-month stay went into effect because she had a letter from her doctor saying that take part in the case at that point because of the surgery. That's the only one I've been able to find. What's this second one that you're referencing?
Well, there was a motion for an adjournment at the final pretrial conference. Mr. Davis.
Oh, an oral motion, you mean?
No. In Mr. Davis's motion to withdraw as an attorney, he asked for two forms of relief. He asked that the court allow him to withdraw, and he also asked for an adjournment. And Ms.
Adjournment for the purpose to allow plaintiff to find new counsel.
Correct.
Okay. But you had never, you being your client, had never moved at that point to dismiss as a sanction for discovery. Is that correct? There'd never
No.
been any motion? And did the court in the record at all say that this, well, and then I'm going to sanction you by dismissing your case with prejudice?
No, it was not a sanction for discovery. And none of the discovery rulings are on appeal right now.
What she was essentially doing, the judge, was she was accepting the plaintiff's request to voluntarily dismiss the case, right?
She was, yes, the.
Okay, so we've got two kinds of voluntary dismissals under the court rule. We have the one that occurs before an answer is filed, and one can simply file that. They don't even need an order of the court. Don't need the court's permission to do it. Soon as the answer is filed by an opposing party, then they need the court's permission to voluntarily dismiss the case. In other words, the court has to either accept the voluntary dismissal or reject it, right? Fair enough?
Yes.
Our case law tells us if the court puts any conditions on that acceptance of the voluntary dismissal, those have to be communicated to the plaintiff. And that was never done here. In other words, the condition here is, sure, I'll accept your dismissal, but it's going to be with prejudice.
Yes, Your Honor. But I think that this case is different because the plaintiff was refusing to come to court. And so this case comes under not only the voluntary dismissals with prejudice, but those cases that we discussed in our brief where the plaintiff refused to come to court. I think the Kroger case is the one where the court had called a trial on short notice. They it adjourned. The plaintiff got into a dispute with her attorney, and then when they came back, she refused to come because she was.
So didn't the trial
upset.
court then prematurely dismiss it? Because she could have dismissed it, or she could have said, well, look, we're going to trial. I'm denying this. And at that point, we're going to trial whatever date is. So current counsel, you show up on this date, plaintiff, you show up on this date. And then if she doesn't show at that point, you got a different situation.
Even so, but she expressed that she was unwilling to come, and she said she would not come. And
But Judge Trebilcock's whole point is, okay, fine. This hearing is dismissed. And, fast forward to the date of trial, the plaintiff either shows up or if they don't, plaintiff's not here, dismiss the case.
I mean, I don't think that a court has to deny a request by a plaintiff to dismiss her case when she says she's not going to come and she's not going to abide.
Sure, but in order to put a condition on that acceptance of the voluntary dismissal, she's got to communicate that condition to the plaintiff. Would have been easy to comply with that. She simply could have said, she could have asked 3 or 4 questions. I want to make sure you understand this. You understand that if I take your voluntary dismissal here today, it's going to be with prejudice, meaning you can't file again, right? Maybe the plaintiff says, yes, I understand that. Says, you understand that it might even affect, your appeal. There might be an argument on appeal that you've waived your right to any appeal here. Do you accept, do you understand that? She might have said yes, in which case it's all been communicated to her, but none of that happened here. Instead, she just dismissed the case. Judge never even said whether it would be with prejudice or not with prejudice. And then, she turns to the plaintiff's attorney, I believe, and says, you still represent this client, submit an order. That doesn't happen. Instead, an order is submitted by defense counsel that says with prejudice, and then it gets signed by the court.
Well, the reason that she told the court that she was going to dismiss was so that she could appeal. She said that she was being denied her rights to due process, that the court was biased, and she was going to appeal. A dismissal to appeal is a dismissal with prejudice, is not a dismissal without prejudice. She wouldn't have been aggrieved.
Was the order that was submitted by counsel to the court, was that approved by her attorneys that wanted to withdraw? Or was that just unilaterally sent into the court?
It was sent in.
Okay, so there was no review by plaintiff's counsel and saying, I consent to this, I agree to form.
Yes, it was not stipulated to. It was submitted under the rule that said that the court can enter it.
Under a 7-day rule? Or
No,
just
the same day.
Just submitted, same day?
Yeah,
Okay.
yes. And I mean, Your Honor, if
I thought it was under the next, it was submitted the same day and entered the next day.
yes, it was submitted the same day, entered the next day. And Your Honor, if the court had just voluntarily dismissed without prejudice, we would be up here arguing, appealing, because that would be completely unfair, where the defendant has been extremely diligent in litigating this case for years. Now, it is true that most of the aside from the 8-month stay, most of the requests for adjournment were the defendant, but that's only because we had to repeatedly.
Which
Your
brings
Honor.
me back to my original question, which is, what is the prejudice besides time and money? If the court, you say we would have been arguing and saying, well, that's prejudicial to us. What is the prejudice? What is the injustice that is occurring beyond time and money, the cost of defense?
In
Are you
under what circumstance? You mean
if
dismissing voluntarily without prejudice?
correct? Correct.
Because all of the rulings go away, all the years that the court has spent managing this go away, and our case law, your case law, Your Honor, says that when a court dismisses without prejudice, it has to protect the defendant from prejudice, and that's the Roslet case and a couple of others that we cited in our brief. So.
And in this case, were there any rulings prior to the dismissal on admissibility of evidence? Were there any motions in limine? Were there any claims dismissed?
No.
Or are you talking about the discovery that was conducted?
Not only the discovery that was conducted, but just the expense of litigating and going up to and being prepared to try the case. I mean, a defendant has a right to have their day in court as well. And Mr. Ahmed was ready to go to trial. None of the delays were attributable to him.
Well,
Yes.
didn't you just concede everything except for the 8-month stay was related to requests by defendant?
Right. Oh, yes, Your Honor. But they were all appropriate. None of those discovery rulings are on appeal here today. The only thing that's on appeal was, and it sounds like counsel has withdrawn most of the arguments in his brief and is only arguing the voluntary dismissal without prejudice. But under your case law, under this court's case law, it's within a trial court's discretion to deny a motion to dismiss with prejudice and instead to deny a motion to dismiss without prejudice and instead dismiss with prejudice when a defendant is going to be prejudiced by having to litigate all the way up to trial and then allowing the plaintiff to dismiss.
Understand and completely agree. I think where you hear, at least myself, I'm troubled with, is that the court didn't go through any of that analysis with plaintiff and discuss the ramifications. I mean, all those are certainly correct statements of the law, but in this case, did the court err or not in doing something or by failing to go through those steps prior to entering the order of dismissal with prejudice?
I don't believe that she did, but even if she arguably did, none of those arguments have been made by the plaintiff and they're not preserved for appeal. I mean, this court is bringing them up for the first time now, and therefore I don't think it would be appropriate for the court to rule on that basis. But we do strongly feel that it would not have been appropriate for the court to just grant a voluntary dismissal without prejudice right after
So your position is the only option the court had in front of it on the day it ordered or accepted the order of dismissal with prejudice, that was the only option for the court. It wasn't without prejudice, and from what I understand earlier, you're saying that wasn't an option for the court to say, look, I'm going to hold this in abeyance. I deny the motion to withdraw. We've got trial scheduled in 35 days. I expect you to be in here in court. This is your counsel. There's too many delays happening. We're going forward with this case with your counsel. We'll see you there. And if you don't show up, then I'm going to dismiss your case with prejudice because, you know, we need to proceed.
I do think the court could have done that, but I do not think it was an abuse of discretion for the court not to.
Fair enough. Any other questions? Any final points?
No, I
We've been pretty hot, so I just want to make sure you covered,
well, and you're
covered
coming
everything
up
you
with
want.
some new arguments here, Your Honor. No, I, before I go, I just want to emphasize that really, and I'm a little bit, honestly, to be quite honest, a little surprised because I thought that the court was the model of judicial temperament and managing this case. The circuit courts, particularly the Wayne County Circuit Court, have a crushing caseload and are required by orders of the higher courts to resolve those quickly. And while the briefing characterizes the circuit court as having been punitive, it was actually the reverse. She listened with care to each discovery dispute. The plaintiff only came to Michigan twice in the entire history of this case to do necessary IMEs, and they were necessary because she was claiming, even though it was a really oddly very minor auto accident, she was claiming a tremendous number of medical issues arising: dermatological, gynecological, intestinal, spinal. So, and again, those are not on review here, except the fact that they reflect that the trial court was really very considerate. Yes, she could have said no. She could have said, no, I'm not granting your motion to dismiss. I will see you in court. But it was not, in our opinion, an abuse, and under the precedence of this court, it was not an abuse of discretion for her not to do that.
I mean, the court gave plaintiff an 8-month stay. I can't remember the last time I saw that.
Not only that, it's like, for example, the IMEs. The defendant had to pay for her costs in coming to Michigan, to driving to the IMEs. They were all scheduled together, and her deposition as well. So, and even on the day of the joint final, the pretrial where we were there, she received the motions to withdraw. She took the plaintiff and her attorneys in camera. We were not there, and discussed it with her. She came back, and if you read the transcript, the judge is really, she's trying to hear everyone out. There was no basis for, I mean, it's apparently they dispute that there was a request for an adjournment. It had to have been adjourned. We were 5 weeks away from a trial where the plaintiff was claiming multiple injuries. The joint final pretrial order was a week later. And the pretrial notice said that if you do not submit that on time, that could be cause for dismissal. Motions in limine were due in a week. So, and the court asked her if she would be willing to proceed pro se, and she said she wouldn't. And she said that she was having these complaints about her attorneys for months. Our circuit courts have a tremendous responsibility, not only to the litigants, but to all the litigants. And I think that I read that each of our civil division circuit judges get something like 1,000 new cases a year. They're supposed to be adjudicating them most of them within a year, virtually all of them within 2 years. This was, I think, 2.5 years in. So the standard for all these things is abuse of discretion. We submit that not only did the trial court in this case not abuse her discretion, but really did virtually everything correctly. Could she have, what is the term in the criminal court when they, ask the defendant if they are willing to
Accept the plea and all.
Yeah, well, I mean, that's, something like that. She actually even did that. She had the Ms. Farmer had 3 competent attorneys who were ready to take the case to trial. She disagreed with them, but there was nothing that would even rise to the level of being entitled to have your attorney withdraw and an adjournment of trial, even in the weighty sense of a criminal trial or a custody matter, right? Or an eviction.
I think we understand.
Okay.
Counsel.
So Your Honor, just before I go, and thank you so much for your time. We submit that the trial court did not abuse her discretion. The issues that Your Honors are raising are unpreserved, and we ask that you affirm. Thank you.
Well, say they're unpreserved, but his very first question presented is that it shouldn't have been dismissed with prejudice. That's essentially what we're arguing here about, I guess. How's it unpreserved? Because it's his first question presented.
I mean, the reason, and nobody, until today, nobody has argued that the court had to go through a either or in order.
But he says in his brief that she should have been, the court should have said that it was going to dismiss with prejudice and didn't, right?
I'll take your word for it. I don't remember that part.
You know what? It's been a long day. Maybe I'm remembering that wrong. I will tell you one thing though. You're both right about one thing, which is I'm looking at Mr. Davis's motion to withdraw, and you're right. He did say that the court should allow plaintiff reasonable time to secure replacement counsel, but he did not ask for an adjournment. So you're kind of both right about that.
What?
Now, we don't know what was said in the pretrial though. I mean, in the pretrial conference, because we don't have a transcript of that.
You don't have the transcript for the pretrial conference?
Or maybe it's all one, unless it's all one. Is it all one transcript?
We never got to the pretrial conference. It's all the same.
Yeah, okay, then,
So-
yeah. I thought reading the record that she met with the parties the parties and their attorneys ahead of time and then went on the record. Is that not the case?
She did.
Okay,
So-
that's what I'm talking about. I'm talking about, we don't have a transcript
Off the
of that.
record
Yeah.
transcript.
Yeah, and I'm sorry I'm taking so much time here. No, what happened was she met with Ms. Farmer and her attorneys to discuss the motions to withdraw. We were not part of that.
Yeah,
Oh.
understood.
And then she went and heard
Okay.
argument on the motions to withdraw and motions to adjourn. I don't know what time to get new attorneys would mean if that's not a request to adjourn.
Yeah, understood.
And it,
I understand. Thank you.
if in the alternative, we would ask that you remand, but we
Yeah.
believe that it was not an abuse of discretion.
Understood. Thank you. Thank you for all your responses and helping clarify some points for us. Counsel, you have a brief time for rebuttal.
Thank you. And I'll be brief. Your Honors, thank you. I agree with counsel on a point. Judge McCarthy is an excellent judge. I think she was respectful. I think she, in some areas of this transcript, exhibited great understanding of my client and empathy for my client's concerns about the Marco representation agreement and such. It doesn't mean that the decision she made was accurate, and we believe that it obviously was not. But as you read through the transcript from that final pretrial, those motions to withdraw, you can actually see this escalate, this discussion. And Sister Counsel indicated that, well, it had to be a dismissal with prejudice because the plaintiff was refusing to comply. Okay, well, initially that suggests to me that this was a punitive measure, which if it was a punitive measure, it's certainly reversible. But if it's not a punitive measure, and let's talk about the refusal to comply. Early in the hearing, my client indicated clearly to the court on the record, so I'm not moving forward with current counsel, and all I have to do is respect your decision because you are the honorable judge who has the right to make that decision. So my client on the record indicated I will comply with whatever your order is. Now, later on, and what Sister Counsel, I think, is referring to is at the end, which I already read, where my client says, well, then you can dismiss the case because I told you I'm not going to go there. You have no right to bring me there. And that's where I think Sister Counsel is suggesting that my client was just refusing to comply. But there's context to that discussion, okay? And you can see the escalation occur in the course of that discussion. Now, some very poignant questions were just asked. One was about prejudice to the defendant. And Sister Counsel did an excellent job of trying to articulate prejudice, but all she really articulated was, we've spent a lot of time on this and we've incurred costs. Well, incurring of costs is not prejudice. As the court knows, there's many remedies. If there was a refiling and it was some egregious action, the new court can dismiss, the new court can require security, the new court can require a bond. I mean, there's a multitude of possible remedies in the event that a litigant is abusing the process and abusing a defendant of their costs. The fact that costs are expended is not prejudice. And there was a question asked, well, whether motions in limine that would have had a preclusive effect or should have stayed with the case. Actually, in this very hearing, Judge McCarthy indicates motions in limine are due August 12th. So the motions in limine, there were none yet. None had been decided at that point in time. Now, the prejudice, if anything, would be to a plaintiff because the plaintiffs have the burden of proof. Plaintiffs are the ones who have to produce witnesses and prove their case at trial, not the defendants. So there would be no prejudice, and there was certainly nothing articulated neither on the record nor in any briefing about prejudice. Final point I wanted to make is regarding the order itself, and it was addressed by the panel, and I appreciate that, the manner in which the order was entered. Clearly, I would speculate that defense appellee's counsel wanted to enter this order quickly and without signature. Okay, because presumably they knew that it was maybe a little bit optimistic to include the words with prejudice as opposed to without, when that was unclear from the verbal record. So this could easily have been a stipulated order, but it was never even proposed for stipulation from the other side. It could easily have been filed under the 7-day rule, giving my client an opportunity to object, but it wasn't even proposed under the 7-day rule. It was filed very quickly without signature. And as you might notice from the order itself, it's only signed by the two defendants' attorneys. Doesn't even show that it was presented in advance to the plaintiff attorneys. So that's really all I have to say. I appreciate it.
Any questions?
No,
Thank you, counsel.
Thank you.
Thank you for your time.
Thank you both.
The case will be submitted. Calling item number 25, case number 373-487, Citizens United v. Celinda Witt. Counsel, please approach and state your appearances for the record. And just, okay, there we go.
Good afternoon, Your Honors. Nathan Pepelinski appearing on behalf of the appellant Cure in this matter. I think just to quickly frame the case, I think it's important to note that this isn't a no-fault case. This isn't a statutory case. This is optional coverage for collision on a vehicle, completely a matter of contract. And I also think it's important to point out that there's no dispute that a misrepresentation occurred in the application for this insurance policy. There's no dispute that the policy specifically asked if she was the sole owner of the vehicles. She said that she was. She was not a sole owner of one of the vehicles. It was actually completely owned by, I believe it's her grandson, Robert Allen. The question presented in this case is, what is a material misrepresentation? And that has been decided long ago in the case of Keys versus Pace, which was reaffirmed in the Ode case, Ode versus Jackson, thereafter. Keys is a 1959 case. It's been established in Michigan, obviously, for all of our lives. And it says that a material misrepresentation occurs when either they would not accept the risk, the insurer, knowing the truth, would not accept that risk and issue that policy, or they would have charged an increased premium. The end decision is whether or not that same contract would have been issued for the coverage that they seek, knowing the actual facts. Ode, reaffirmed that shortly thereafter, the Court of Appeals started to stray away from that standard and try to delve into the misrepresentations and look at how extreme they were and what they were going to be. Ode said, no, you do not do that. The question is whether they would make the policy, the same one, this policy. Would they issue that same policy if they had known the true facts?
Should that be a question of fact or a question of law?
That's a question of law. Well, it would be a question of fact if there's disputed evidence on that fact. In this case, the only evidence that we have is the affidavit from the underwriting department that said we would not have issued this policy.
How would there ever be a dispute? How would there ever be countervailing evidence to that?
Sure. I mean, it would be difficult. It would be difficult. But if you insured another policy, another vehicle, and they said previously, okay, we don't really care about this issue. And you could have testimony to say, hey, they insured the same type of vehicle, even knowing these facts. It didn't cost anything more. It would have been the same.
Remind me, was this a C8 or C10?
This is C10.
Okay.
And in your client's disclosures, did they disclose the underwriting documents?
I don't think so. I don't think there's any underwriting documents, but the standard is set by this court several times is that the underwriting guidelines are established by an affidavit. They've done that in the Lake States case. They specifically said the guidelines can be established via affidavit. That was reaffirmed in the 21st Century Premier the Zupfelt case, said the same thing. They're looking at what are the guidelines. So the guidelines are established by the affidavit because there's going to be various guidelines. There's not a set standard in the state. Could the legislature create one set of guidelines for every insurance company? Of course they could. They've chosen not to, likely because it would drive out several insurance companies from the state.
Instead of disclosing the guidelines, they just attach to their disclosures an affidavit that says what the guidelines would have said as it pertained to that case, right?
Your Honor, I'm not sure what the actual initial disclosures contained because I was not trial counsel. I know the affidavit
Always
was
fine to say you don't know.
Yeah, I don't know. I know it was attached to the motion. And that's how it was established. There hasn't been any blowback on other evidence. There was some attack below on whether or not the guidelines say what they are. And I think that the law that I've cited in the cases, these cases specifically say, in fact, I believe even Howard, that I will talk about shortly, was an affidavit case that they dealt with the affidavit, not specific site guidelines. There's no case that I'm familiar with ever from the state of Michigan that says that you have to have written guidelines and they have to be submitted to support a claim of a misrepresentation. I've dealt.
And so to state your case is that there was a material misrepresentation because failure to disclose the grandson, they wouldn't have written it or it would have increased costs.
Right. So they would
because of
not.
that, under the policy, we have a right to void the contract.
Exactly, Your Honor. In
Okay.
fact, what it would essentially be, cure requires that the owner, the specific owner of the vehicle, be the named insured for the policy. So it would be a completely separate policy. It would affect the pricing for multiple vehicle discounts and all those kind of things.
Yeah.
When you think about it, it goes back to the ancient idea of the wager policy. A person that's not technically the owner of a vehicle, while they may have in Michigan no fault some interest to insure of their grandchild or something. But when you're getting into collision coverage, you have somebody that's not an owner of a vehicle who could profit by the damaging of that vehicle. It's not the owner of the vehicle actually insuring it at that point.
So what's your best summary other than what you've laid out in your briefs in terms of how the trial court then erred?
So I think
what did they miss?
There is some confusion.
If it's so clear, what did they miss?
So I think if you don't read Howard carefully, it can create some confusion. So the Howard case is very unique in that there's 4 cars insured. 2 of them are insured first back in 2014. A third vehicle, the Mariner, is added in February of 2019. That policy that exists, they add a 4th vehicle, a Yukon, in April of 2019.
How did they do this? Did they do this via an agent or otherwise?
I think I'm not sure they're really clear on that. I think it's over the phone. They add the application. Essentially, it's another application to add these vehicles in Howard. So if you look at what they sought, they did not seek to rescind the policy back from the inception. They sought to rescind the policy to the essentially 4th vehicle, the
date
third
the 4th
edition.
vehicle was added.
Yeah, the Yukon. Well, at that point, you already had a policy of insurance existing for the Mariner. You've already made an agreement. You already had coverage in place. You've already agreed that this would be what we would cover this vehicle for. We agreed to cover it knowing all these facts. The misrepresentation only occurred in that 3rd application regarding the Yukon. Had no effect on that. And that's what the Howard essentially says. It says, I think at least 3 or 4 times, it says it's not in the application regarding the Mariner. The accident involved the Mariner, but the misrepresentation completely had no relationship to that insurance policy that had already been issued. So in the end, I'll quote the language, which I think is important. In Howard, it says, the purpose of permitting rescission of insurance policies when there has been a misrepresentation is to protect the insurer from having to pay claims under a policy that, but for the misrepresentation, would not have issued. In Howard, a policy would have been issued, but for the misrepresentation because it already occurred. In our case, it's completely different. There's only one policy. That one policy would not have been issued. Could there have been separate policies? Absolutely. They could have, maybe. I mean, telling all of the truth, maybe there would have resulted in 2 different policies, but that's not the standard set by the Supreme Court. Standard is whether or not, based on this application, would they have issued this policy? And they would not have. There's no disputing that. I don't think there's any factual way to get around that.
Because of the case, it says you can accept the affidavit.
Right.
Okay. I think we understand. Okay. Do you have any other additional points that you feel necessary to get in or say for?
There was some discussion about innocent third parties to the misrepresentation because the misrepresentation occurred by Miss Witt. And I think there's some claim that one of the grandson also owns the vehicle. But Howard makes clear that the balance of the equities just does not apply to optional coverage. It only applies to the statutory mandated coverage. So that is not something that we would get into. So I would request that your honors reverse the decision of the trial court. Not to cite an unpublished opinion, but there is one cited in my case that in my briefing that is very on point. The Kodra case, which is on page 29 of my brief. It covers a lot of the same arguments. It's unpublished, but it was in 2022, so it's fairly recent. Thank you, your honors.
Thank you.
But I have a question for you. So when the employees from the insurance company take this information over the phone for the application, are those phone calls recorded? And if so, is that recording part of the record?
I am not sure how this was specifically completed. I think it may have been completed online. We have the application attached as an exhibit that includes the information. It includes the application, includes a specific agreement that she would agree that the policy can be voided if there's a misrepresentation committed in the application. She signed that underneath it. There's been no challenge in the trial court to the application being valid.
Thank you.
Thank you, counsel.
Thank you.
You have some time for rebuttal. Good afternoon.
Good afternoon. Francis Murphy on behalf of Celinda Wett, Antonio Allen, and James Allen. And it's nice to meet you. This is my first time arguing in front of the Court of Appeals.
Welcome.
Thank you for having me.
You made it up to the podium. There you go. Half the
I
battle's
know, here
done.
we are. So,
Before you get started, and
Yes.
again, if you don't know the answer to this, please just tell me you don't know. Do you know how this policy was procured, whether it was through an agent or on the telephone or online?
I believe it was online.
Okay, thanks.
We're requesting that the court either affirm the trial court's decision or alternatively find that there is an issue of fact regarding whether the misrepresentation was material. Cure brought this declaratory action. We filed a summary disposition motion as a first responsive pleading, so there has been no discovery performed. The focus on materiality is whether a reasonable underwriter would regard an application answer as sufficient to reject the risk. And Cure has produced an affidavit demonstrating that ownership alone creates an uninsurable risk. I could not find a case where any other insurance carrier has found that a misrepresentation as to ownership alone creates an uninsurable risk. None of the cases cited by the defendant, whether it's Westfield, Lake State, or Codra, involve facts where ownership alone was sufficient to deem the risk uninsurable. In all of those cases, there are additional facts such as undisclosed drivers, undisclosed household members, licenses having been revoked, household members who had not disclosed prior drug driving offenses, prior suspended licenses. So to create a question of fact regarding materiality, we must bring forth some evidence to question the testimony of the underwriter. And that's from the Michigan Supreme Court case Ode. I think the fact that I've not been able to find another insurance carrier other than Cure who finds this to be an uninsurable risk, and the fact that there are no other factors or facts in this case to demonstrate that it's uninsurable, and the fact that no discovery has been performed, either it creates a question of fact or the case should be remanded to perform some more discovery.
How do you, I mean, counsel says, look, controls, all we need is an affidavit from somebody at the underwriter at the company that says we wouldn't have done this had we known the true facts. And
Well-
that's all we have to produce. And he says, then it's incumbent on you. You've got to come up with something to rebut that. What is that besides speculation?
Well, Ode also says that, so, I mean, I don't think that it's speculative if you look at all of the cases that have been cited by either us or Cure, there is no case that says that ownership alone creates an uninsurable risk. That coupled with the fact that they knew James Allen was the driver, who's going to be the sole driver of the 2020 Nissan Altima. They knew that the vehicles were financed. There was nothing to alert Miss Witt that she was the listed owner. They had perfect driving records. There was no everyone was properly disclosed on the policy. And Cure admits that it does not always rescind policies based on ownership interest alone. So I think these facts and the case law call into question whether a reasonably intelligent underwriter would reject this risk. And, I think because of the fact that this was decided on a summary disposition motion as a first responsive pleading and the chilling effect that would occur based on such a minor misrepresentation, allowing for the complete rescission of a policy, that if the court is even leaning in that direction, there should be at least an opportunity to perform some discovery on that issue.
Point, if you wouldn't mind, just because I don't have it at my fingertips, I was checking that, is point where you say Cure admits it doesn't always rescind the policies for that. Where is that in the record?
So that's in the,
Answer to a request for admission.
Was that an answer to the request for admission?
Yeah.
Okay, I couldn't pull that up. That's why I was just wanted to get that nailed down.
yes. With respect to Antonio Allen and James Allen, they are innocent third parties. They did not make any misrepresentations with respect to the ownership interest. And this case is distinguishable from Howard. And Howard, it was the named insured who made the misrepresentation. And the Court of Appeals said that in that case, we're not going to balance the equities and the basis for not rescinding the policies because we didn't believe the misrepresentation was material. So here we do have an innocent third party. We have people who are not named insureds at all. And in Lake State versus Wilson, a case cited by the defendant, for innocent third parties, even for optional coverage, it is relevant whether fraud could have been easily ascertained. And in this case, it not only is it easily ascertainable, it was easily ascertained. All they had to do was quickly perform an accurate search, and they found out that the vehicle was owned by Miss Witt. So, you know, I know I'm quoting the same thing that Brother Counsel quoted, but you know, a misrepresentation that is immaterial to the coverage in question should not be an excuse to deny or rescind the coverage in this case. And that's exactly what they're doing here. So as to Celinda Witt, I'm requesting that you affirm the trial court or remand the case to determine if a reasonable underwriter would consider this risk uninsurable. As to Antonio Allen and James Allen, find that they are innocent third parties and the policy is not void as to them.
Thank you. Any questions?
Thank
Any
you
questions?
very much.
Thank you. Nice job for the first time.
Briefly for rebuttal, your honors. There have been several cases that I did cite regarding the ownership issue being a right to rescind. The Hamoud case is a published opinion that's binding. The Kodra case that I mentioned earlier, while being unpublished, specifically addresses this issue because while there were other grounds that could have also been relied on, the court specifically addressed the ownership issue, and that was the reason why it ruled the way it did.
Right. What about counsel's suggestion that insurability, that should be a question of fact that's tested and you weigh some of the equities such as, you know, the alleged fraud, the timing, that could have been discovered, that easily Cure could have done a accurate report or, you know, some other reporting and found out, well, that's not the true, you're not the true owner. You put it on the application, you either say, look, we'll give you a policy, but it's going to cost this because, you know, it's got to be this owner, or we got to do another policy. Why isn't that the burden of Cure?
Sure. So, Your Honor,
you know, they bring this up after everybody, they think it's been issued, everything's good, they're out driving, you know, they think they're insured, they think they're covered. And then when there's something bad happens, Cure pops up and says, oh, sorry, we could easily discovered this, but we didn't. And now we're going to deny coverage after taking months and months of premiums.
So there's several points on this. The easy ascertainable rule has been rejected by the Supreme Court in Titan versus Height. The Supreme Court has specifically said the insurance company has no duty to investigate any of the answers. They have a right to rely on it. It's the formation of any contract. When you think about what's going on here, it's a formation of a contract. And you're saying, can one side get to lie to you? And you have to go and catch them. It's just not feasible, really, when you get into the insurance world, because this used to happen. They used to have to write binders. So they would write a binder of insurance. It was essentially meaningless for that month while things were investigated. And what that meant is you never knew if you had insurance or not. You thought you had insurance, but then you had to wait while an SIU investigation occurred. It would slow down, especially in Michigan, where we have resident relatives and all those kind of issues. It would slow things down to a crawl because the only way you're going to get the investigation done is if you send people out to the house and you start watching them come and go. So the easily ascertainable rule has been rejected. The law in Michigan is that you have to tell the other people that you're contracting with the truth, and you especially have to do that in the insurance company. Who could have easily ascertained this information? Miss Witt. She knew she did not own this car. She knew that when she was checking the box. There's no mistaking. Maybe I own this car, I just don't know. Well, guess what? When you're filling out the form in the end application, it specifically says, hey, if any of this stuff is false, if any of this is a misrepresentation, it voids coverage. So don't do that. And I think there's also a warning about falsely submitting information for insurance coverage is a crime. So there's warnings.
What would be the
specifically given.
motivation in her situation to check the wrong box there? I mean, she's telling them that this child of hers is the person that's driving the vehicle. What motivation does she have? I mean, in other words, can you easily argue that it's just a inadvertent mistake? I mean, absent some type of motivation?
Sure. So there would be a motivation because you do get multiple car discounts and those increase with more cars that you have insured. I am not sure what.
You can't get a multiple car discount in the household. In other words, I own car X and, my son owns car Y. And we're both in the same household. You can't get a multi-car discount in that situation?
My understanding is it would be a different insurance policy, so that you can't have a multiple car discount when that one car is insured on a different policy. So that one vehicle would have been required to be insured under his name, not hers. So she can insure the cars that she owns. She can't insure the car that she doesn't own. And again,
I've just seen, I don't know, countless examples where you had like a husband and wife, and the wife was a titled owner to one car and the husband was the titled owner to the other car, and yet they get the same policy, multi-car discount.
Sure. And a
Is
husband,
that different?
yeah, a husband and a wife are different. One, because they own property automatically in connection with each other. Two, just because you're a titled owner doesn't mean that you're an exclusive owner. So if you had the use of that vehicle, husband and wife generally have the use of the vehicles. They both can use either one without having to ask permission. You don't have to, like your wife generally doesn't have to say, can I take your truck this time? She's an equal owner of that vehicle. If you have use of a vehicle for 30 or more days, including looking forward 30 days. If in the future, the next 30 days, you get to use this vehicle, you're considered a legal.
Is there any other motivation you can think of other than this hypothetical multi-car discount?
And I don't know the motivation, Your Honor.
I know you don't know it.
I don't know it. And
could you think of one other than the
other than
multi-car
saving money? No, I think that's usually the motivation. But
no, I mean, maybe she could have saved money in some other way. And in other words, is there some other reason why people would do that? You've already given us one reason. I'm just wondering if there are any other.
I don't know, Your Honor. And to be honest with you, it's a bit of a red herring because even if it's an innocent misrepresentation, even if she completely didn't know that what cars she owned.
No, it wouldn't be that. It would be that she checked the wrong box.
Yeah, even if it's an innocent misrepresentation, the law does not make a distinction between an innocent and an intentional fraud. Innocent misrepresentation is equally enforceable. I have those cases in my brief.
Can you respond to Ms. Murphy's point that she made about she wasn't able to find another case where there was a different insurer out there that was arguing that they would not insure a car if it wasn't owned by the named insured? Can you think, and I apologize because I'm probably going to ask you to repeat yourself because you might have already said.
Yeah.
Well, what are some cases that say that?
The Kodra case that I cited earlier. Okay. The Hamoud case, I think there may have been more than one issue in that, but one of the issues was the ownership of the vehicle. In fact, Howard itself is an ownership issue. They don't say that this is an irrelevant point. They say this is a material misrepresentation, but it occurred in a third application, not the application that's at issue here. So I've never seen a case that has ever said that you could insure someone else's vehicle. And again, it goes back to wager policies. You cannot insure somebody else's property. It's like long ago, you used to be able to insure people's lives. You could say, I'm going to take a bet that Judge Trubblecock is going to die in the next year. I could take out a life insurance policy.
Thanks for putting that out in the universe for me.
So I could take that out and I could say, I could make that bet, but they can call that a wager policy and it's illegal now for obvious reasons. And it would be the same thing with the ownership of a vehicle. While there may not be much motivation to damage this vehicle or destroy this vehicle, there's certainly more motivation than there would be if you're the actual owner of the vehicle.
Understood. Any additional? No additional questions?
No,
Thank you,
thank you.
counsel.
Thank you very much, Your Honor.
For responding to all their questions and the solid briefing. That case is submitted. Item number 26, case number 372797, N-Ray T.R. Pritchett minor. Counsel, please approach and state your appearance on the record.
Good afternoon. Timothy Pinto, representing respondent, father appellant Taiwan Pritchett. As I mentioned, I'm representing the father here. It's impossible to even talk about this case without mentioning his mother, the grandmother in the case. This was a case where from the very beginning, it was clear that the parents weren't going to be able to care for the child. The mother had a previous termination, gave birth to the child with cocaine in the child's system. And actually her rights were terminated very quickly after birth. But the grandmother from the beginning went to the hospital, wanted to be available, wanted to serve as the guardian, went to the probate court and said she wanted to be the guardian, approached the department and said, I want to be the guardian. And they said, wait, please, until there's a foster care worker in place. And then before the next hearing, they placed the child with somebody else.
That other person was a relative?
The other person, so the original placement was with a great aunt on the mother's side.
And then she passed. And
She
then-
passed.
Then there was another.
And then there was a placement with a great aunt who was 70, who had health problems.
Placement was always with another sibling, right? Was that the reason that the foster worker gave for
I
choosing
think that was part of the calculus. A couple things to say about the grandmother. It was clear she was very interested. She showed up to 20 hearings over 4 years. She was licensed as a foster care parent. She eventually, because the court ordered it, got visits with the child. DHS did not set those up. And the father repeatedly was requesting that she be named as the guardian.
The court, there was no finding below. The court didn't see that the grandmother in other circumstances would be an okay placement, would be adequate placement. But this case, weighing all the factors, decided not to. That's what we're dealing with here, right?
Yeah, so I don't want to come across like I'm making a request that we have a foster care placement hearing here.
Yeah. I understand.
I believe that she was the obvious choice. And by the way, the legal guardian ad litem in the case was in support of maintaining a relationship with the father through the grandmother's placement. But no, there was no finding that she wasn't, there was never any finding that she wasn't adequate. In fact, they never did a home visit for a long time. Ultimately, they started letting her have visits. After the child turned about 1.5 or 2, she started visiting with the child every other weekend. I don't think there's a shred of evidence here that she wasn't the perfect person to take care of the child. But again, I can't stand before you and say that's the error.
Right.
The error is that because she existed and because the father repeatedly pointed to her as the person that he wanted to care for his child, the error is when you get to termination of the father's rights, you cannot do that.
I understand that the grandmother being put forward is probably his best and strongest point, correct, for non-termination. But what are we to make of all the other factors that I see as being pretty negative?
So let's
Failure
talk.
to follow the treatment plan, when he's out, doesn't go visit the child, those things that are in the record.
Yeah, so I'm going to take it in 2 chunks. I don't want to draw it out. I know you guys have breezed through lunch at this point.
No, take as much time as you
Yeah,
need.
you
It's
do what you,
significant,
yeah,
yeah.
take your time and do what you.
In my
what's
mind, there's
important.
2 pieces to this TPR decision.
Yeah.
The first is, are there grounds to terminate in the first place? And as we argued in our brief, as soon as he points to the mother, it's not even fair to start pointing to his failures anymore. Because In re Mason says, you are entitled, you have provided proper care and custody as soon as you pick someone in your family who can
Because he
do that.
acknowledged, he said, okay, I'm not able to do this, so I'm
Correct.
delegating that to my
That
mother.
is In re Mason. That is the Michigan Supreme Court's holding in re Mason is you can be in jail. You can be absolutely incapable of providing care. But if you have someone else in your family who can do it, you cannot be accused of not providing proper care. And now the department raised other grounds, not just not providing proper care, but also said that he had abandoned the child. But that requires that you show he's not making any effort to take custody. And he was participating in all these hearings regularly to do so. As we lay out in our brief, each of those grounds fails, but the big chunk of them fails because his mother existed, who was ready, willing, and able. Then when you turn to best interest, even if this court were to find somehow that there are grounds to terminate, the other thing the trial court has to do is it has to make a finding that termination would be in the best interest of the child. And I'm going to mention the legal guardian ad litem again. In this case, the LGAL opposed termination. And I hope that sets off alarm bells for this panel because that's pretty rare. Usually the LGAL goes along with whatever DHHS wants. But here, the LGAL opposed termination because there was an opportunity for a relationship with the father and there was a grandmother ready to provide care. And so when Your Honor says go through the factors, the factors that you have to consider on best interest, there aren't many that you have to consider. One of them is you must weigh relative placement against termination. I know the child wasn't with the grandmother, but there still was a relative placement here, which was the great aunt. And what did the court do? The court did not say, I'm weighing that against termination. The court said, well, there's lots of people here who would adopt this child. And so that to me is a reason to terminate. No, you cannot do that. That is absolutely in violation of In re Mason and In re Olive Metz. You can't weigh it in favor of termination that they're with a relative. You must weigh it against. Is it dispositive? Of course not.
Was a proper course then to remand for proper consideration of the factors?
At a bare minimum, yes. I think this panel is required to remand on that ground alone, the relative placement failure. The other thing I would say about best interests, again, there's not a lot of guidance about things the court must do. That's one of the few things they must do. But the Michigan Supreme Court came out with a decision this year, which was not cited in our brief, but is from January, In re JMG, JGG, something else. It's 16 Northwest 3rd 82. And
was that provided as supplemental authority or no? You're just providing it here today?
I don't think so. I wasn't counsel when it came out, and so I'm not positive.
Can you give me that site again?
Of course. 16 Northwest 3rd 82. And there, the Michigan Supreme Court offered what I think is really important guidance on best interests, which is you shouldn't be trying to figure out, can this parent take full custody? That's not your job at best interest. Your job is to determine whether retaining the relationship in some form would be beneficial to the child. That's the mission. In some form is maintaining a relationship. And here, the evidence was that there's a grandmother ready to care for the child, even if the child stays with this great aunt, which again, I think is the wrong decision, given how old she is. But the father has a bond. The father is interested. The father has tried. The father has a grandmother who will help facilitate this. And the LGAL said, I wrote down the quote because to me, it's almost almost the full answer. There's a chance to save this relationship between this father and the son. If the LGAL thinks that, that's not me arguing that. That's the LGAL saying that. That to me is a reason the termination is wrong here. And I don't see anything in the record other than the trial court's statement of, well, there's lots of people who can adopt. That's not an affirmative need to terminate. That's just, well, we've got a plan if termination happens. But if you had testimony, there's one great person, the great aunt is the perfect person, and she won't continue to care for the child unless she can adopt. That makes sense to me. But there's got to be some reason to terminate as opposed to we can close this case. And that, I think, is the real error here is they jumped to the most extreme possible solution without any need to do so, and an obvious solution that would have been way smoother, which is the grandmother.
Any additional questions? Thank you, counsel, for your great briefing and service to the court. Thank you for taking on these cases. They're very important cases, and your advocacy and representation is much needed. And so thank you very much.
Yeah, thank you for your time and attention.
Just one quick question to that. The GAL that you referenced was the subsequent GAL, not the first one that got taken out of the case.
That's right. Yes. At the time of termination, though, opposed termination. Yes.
That's Mr. Carlissimo, I think.
I don't remember the name.
Okay, that's okay.
Yeah.
Thanks.
Item number 26 is submitted. Our last item on today's case call is item number 27, case number 374-688, in re MRG Delano minor. We do have a Beth Ann Miller certified for oral argument, but no one has checked in. So no one calling checked in. That will be submitted on the briefs. And that concludes our December case call here in Detroit for panel one. Thank you very much.
Thank you.